an extraordinary event, and that we're continuing today.
Recording in progress.
Actually, I will say that this event is going to continue much longer even than just today, because today we're going to be creating the consortium. The Brazil-Japan Law University Consortium. And as we've announced yesterday, the next Congress will be in São Paulo in 2027. In 2028, it'll take place in Paraná. And a year after that, in the first semester, we intend to organize a trip of the Brazilians to Japan. Half of them professors, and the other half Japanese descent lawyers. It is the first time that we will have a group such as this that will be going to Japan. I'd like to invite Justice Nancy Rodrigues to take her seat. I'd also like to remind you that we have today 2 panels. This first one is the 4th panel on consumer rights, and I really would have loved to stay here. I think everyone knows that this is one of the areas that I really enjoy or like the most. And as a co-rapporteur of the Consumer Code, I would love to be here, but at 9:30 we have an international event on arbitrage. But Justice Nancy refused to moderate that panel in the International Congress on arbitrage to be here. I have to do the opening here, and then I'll be back. And afterwards, at 10:30, we have an extremely interesting panel on the future of the legal practice. And this is not just lawyer, I mean all the way from professors, academia, to lawyers, to judges, magistrates, and members of the Public Prosecutor's Office. Now, it's the first time that I'm having a panel with such a composition. I thought it would be really interesting to compare with the presence of several university deans, law school deans, and to see what is happening and what can happen. We're more interested actually in what could happen. At midday, we will have the closing ceremony presided by Justice Carlos Muta, ex-president of the 3rd Region's Supreme Court, and having Professor Kazuo Tanabe's presentation, who I do not need to introduce. His name in Brazil represents a great deal of things. And one of my mentors used to say that they were really close friends. And she used to say, I would give her a text, for example, the text on the consumer rights or defense. And I would justify something if it was an amendment, for example, and she would say, I'll ask her, did you like it? And she'd say, yes, I liked it. Yes, but the justification, you need to change it. It's too long. Right, like Kazu. Actually, she didn't say Kazu. She said, right as the Japanese. And I knew who she meant by that. And once she even said, when Kazuo writes, you can't remove a single comma because the whole text falls apart with how precise he is. So, just a little story about this very extraordinary legal practitioner that has always been at the vanguard of the big subjects. And another pioneer, we know Professor Masato Ninomiya, that spoke yesterday. They are both. Professor Ninomiya, the day before yesterday, was saying that in this group, there are already grandchildren that are working in law practice that are pioneers. His intellectual grandchildren. So a student of his student. This shows a little bit this trajectory that we wish to pay homage to here. And so we have the intention in this opening session to pay homage the ex-minister counselor, so the vice ambassador here of Japan, but I do not know if he's online. So the deputy head of mission, ex-deputy head of mission. Ah, there he is.
I'll switch to English so he can understand. Can you hear the interpretation? Can you hear the interpretation or no? No? Se eu falar em português, entende?
If I speak in Portuguese, can you understand me? Yes? Okay. Very well. I have requested that the Minister Counselor be present here with us online because we've already had the opportunity of saying many times throughout this event that without him, we would never have had such a well-organized event. He dedicated himself personally and demanded that along with the ambassador, he be present here in a meeting that, if I'm not mistaken, the day before his departure to Japan. And this is what I call dedication. As someone who has studied law, and by the way, was succeeded by a minister counselor that is also here with us and that studied law as well. So it's almost as if it were a requisite here in the Embassy of Japan that the minister counselor be a law graduate, which is very helpful for us, of course, because sometimes relationships with other embassies are not do not flow as well, because those who are there do not understand the importance of law, especially on subjects such as these. So I would like to make the most of this opportunity of his presence here to truly thank him and hope that he come back to Brazil. We all know of the love that the Minister Counselor has for Brazil. He wrote a book that was referenced yesterday by one of the speakers. I think it was about the conclusion of the book that was mentioned word by word, and this indicates the extraordinary value that this Japanese diplomat has, and I would like to honor. And without further ado, I hand over to you, Minister Counselor, so that you may speak to us. The event is being very successful. We're all very happy to be here. Yesterday evening, we were very tired at the end. Not just the Japanese who had to travel, but the Brazilians as well. Although the jet lag was, we didn't have any jet lag, although we haven't traveled 30, 40 hours as our Japanese peers have. who came from Japan, but we were also very tired. So I hand over to you, to this extraordinary diplomat that I very much admire.
You can speak now.
You may speak now, sir.
You can speak.
Good morning.
Good morning. Yes.
To be included in this great session. I understand that the session yesterday was a great success, thanks to your leadership and also the participants from both Japan and Brazil. It gives me a great pleasure to see this project of yours to come into fruition and even to further advance for the next stage. So once again, deep congratulations to all of the participants, and I wish you all the best in the future endeavors, especially for the third conference, Law Congress, and of course the bilateral collaboration in the judicial and academic areas. Thank you once again, Chief Justice Herman Benjamin.
Arigatou gozaimasu. Bem, eu agora vou pedir.
Okay, now I'm going to request Justice Lydia to take over, that she sit at my place, and I hand over to Justice Nancy Andrighi. As you know, she's our great jurist. She doesn't like it, but I always say it. Our dean. But we say it's not dean in the sense of age, but because she came in here almost straight from kindergarten. It's because of the respect and the admiration that we have for your work. It's unanimous. You can ask any Brazilian law practitioner or jurist. And yesterday, one of the professors mentioned your precedents in the court. So I hand over to Justice Nancy Andrighi. I invite the president of the Supreme Court of Paraná, of the state of Paraná. Good morning, everyone. Good morning, Chief Justice. Thank you very much for reminding everyone that I am the dean of the court. You know how much I despise that, how much that hurts me. But nevertheless, I will still wish you an excellent day. I know that you're going to preside, you're going to chair an opening of a very important event that Justice Benjamin is also programming and undertaking currently in the court. Thank you very much for your efforts. It is a court that is going to see your administration as a watershed in the history of the National High Court, the STJ. Never has the STJ had so many important events and had so many relations with the world through directly. Thank you very much, Chief Justice. Good morning, dear Justice Lydia. It's a pleasure here to have you chair this panel. First of all, I'd like to think that you all feel lovingly embraced by me. It's a moment of extreme joy to be presiding, to be chairing this table, this panel, and to be close to our idols. Us as students and as magistrates, we have idols as well, and mine is present here. Professor Kazuo Watanabe. I see him, I look at him, and I see stars. So much so, you've taught me so much. I've learned so much as a magistrate, as a human being from you, and how to behave within the judiciary branch. I thank you, and I pay homage to you every time I meet you, and I'm very happy to say several times, thank you very much, Professor Kazuo, for so many lessons. Very well. So our program today, Justice Legion, is consumer law. It was in the 20th century that new rights were effectively made. And it was said that the 20th century was the century of the new rights. And as a branch, we have civil law, and from this branch, we had environmental law, consumer law, space law. They are all parts of the study that we're doing of private law. Some historians say that it was in the 60s that the consumer truly started being respected and recognized as a person that has rights maintained and with tutelage by the state. And we have as an initial benchmarking message from President Kennedy on the 15th of March of 1962, when he sent the message to the National Congress for the protection of consumers. And in this message, he numbered the basic rights that the consumers would have: health, safety, and information. And at the end of the message, he wrote the most important part, that the consumers be heard. So some historians that are writing now about... I apologize, I had some health issues, so my voice is not well. So all the historians that are writing the history about consumer rights, consumer law, mention this message as it being the world start of the creation of consumer rights. And we always talk about this last message in President Kennedy's message, that consumers be heard. That might be the most important part. But I also researched. I'm not gonna give you a presentation, I'm sorry, but I just want to bring an important question, especially for Professor Maeda, because for some years I studied what the first legislations would be that we have in the world on the Consumers Code for defense of the consumers. And I chose the Hammurabi Code to see if we would already had some kind of norm written in defense of consumers. And I actually found a lot. But one of them, well, several of them left me completely angry about it. But especially one, it was Article 108 of the Hammurabi Code. And this article says the following: pay attention to the gender. If a female tavern worker does not accept wheat at the price it is, but takes the money and the price of the drink is lower than that of the wheat, she must be convinced of this and thrown into the water. So the sentence she would receive is that of death.
So I would just like to share this message to share with you how much we have evolved when it comes to our consumers. But still, these rules, they were a little seed so that we could be so evolved now when it comes to consumer law. And I would like to start this panel now. apologize to our chair, and I would like to immediately pass the floor to Professor Laura Schertel Mendes that I met when she was a little girl. She is the coordinator of our professional master's course at the IDP. Oh, Dr. Ronaldo would like to start. Okay. Yes. We are going to invert the position because Professor Ronaldo Porto Macedo, he has to take a flight soon. And he had even told me about that yesterday, and I apologize because I ended up forgetting. Professor Ronaldo Porto Macedo is the Vice Dean of the Faculty of Law from the University of São Paulo, USP, and he is a professor there. He is a former prosecutor from the courts in São Paulo, and he is a professor also of philosophy and general theory at USP. I would like to pass the floor to you, Your Excellency, to start this morning's panel. Thank you.
O horário é 15 minutos. Lá está o.
Bom dia a todos.
Good morning, ladies and gentlemen. Thank you so much, Justice Nancy Andrighi. For me, it's a great joy to be able to participate in this event, which is extremely important, not only because of the exchange of ideas that we're having, but as I come and say, because now I am the Vice Dean of the Faculty of Law, it's important because the cooperations, the agreements, they not only happen when we have a formal agreement, but especially when we have some kind of human interaction, and mainly when we have a human interaction that is face to face and not only online. And this opportunity has created that for us, the opportunity to get to know one another, to meet one another, without which the agreements never move forward. I would like to start my participation by apologizing to you. It is a Brazil-Japan meeting, but as it has already been said, I couldn't cancel my appointment in São Paulo. And so I'm going to leave this room in a French manner. What do we mean by this in Brazil? Leaving without saying goodbye to any of you. I'm going to leave this Brazil-Japan Law Congress very discreetly. Without further ado, I would like to make my remarks, and I'm going to talk about the panorama of the main problems that we have been facing, mainly the challenges, the new problems, the new challenges. Recent data from 2026 created by Senacom, which is the national body that follows up consumption in Brazil, reveal that the champions of complaints, 62% of them are the financial institutions and the banks in Brazil. In second place, we have credit analysis services, mainly a body called Serasa. They are responsible for the credit scores here in Brazil, analyzing the individuals in Brazil who are in default, who haven't paid their debts, and who are considered bad consumers. In third place, we have the shops, the retail shops, digital retail shops. But these pieces of data, I try to compare it to another body that defends consumers in Brazil, and it's a very important body, even more important because of the volume of complaints. And we have the PROCON. PROCON is the Consumer Protection Agency. And there are statistics that 34% of the complaints regarding financial services and banking services, 26% of them, almost 27, are related to e-commerce services on platform, and almost 19% services, essential services, basically sanitation, electricity supply, and 10% telecommunication services. And these data reveal many things, many facts that could be summarized. In first place, the main problems that are impacting Brazilian consumers are problems related to services, a society based upon services, then a society that sells products, continuous products. And another characteristic is that these services, they are usually regulated services that are monitored, and they depend on an intervention, continuous intervention, mainly from our regulatory agencies. This is the model we have in Brazil. We have the National Regulatory Agency for Telecommunications, National Regulatory Agency for Water Resources, etc., and other financial services from the Central Bank of Brazil. Besides other problems related to sectors and industries that are not very well regulated, mainly e-commerce, the e-commerce industry. I would say that considering these empirical data that we could list, and I'm going to list them to select a few topics, the following problems, the most important problems that are part of the concern agenda when it comes to consumer protection. First of all, data protection and e-commerce. And I believe my fellow panelist, Dr. Carapeto, is going to discuss that. And the marketplace, the platforms, the civil liability of these platforms, the sales, publicity, digital publicity and marketing, mainly the actions aimed at trying to manipulate consumption preferences, and also to obtain information, the profiling, so that they can micro-guide people's consumption preference. The adherence contracts, that now this is a classic problem, and mainly with the dynamic contracts, relationship contracts. I'm going to discuss this a little deeper. And the contracts that are monitored and controlled by AI. So they are relational contracts in which the vast use of AI has been changing. And also guarantee, insurance, and the vulnerable consumer. It's not only the vulnerable consumer that we presuppose that they are vulnerable because of the law, but specific categories of consumers that are especially vulnerable, become especially vulnerable. And we have new categories based upon these technological changes. And AI evidently is bringing new dimensions to this hyper vulnerability of these people. Sustainability, responsible consumption, AI, because it goes through all of them, the algorithms, transparency, our population, how these campaigns are targeted. And finally, I would like to attract your attention because consumer protection within this context in which so these agencies, they play a fundamental role trying to protect the consumer, and they make us think action. So these are the first remarks that I would like to make. E-commerce, technological changes. Basically, we have challenges related to the super indebtedness of our population. This is a current problem. You can see it on the news, you can see it on newspapers. And the World Cup even made this even more evident. We have bet agencies and bet companies that operate online, and they have been generating amazing and terrible data. The volume of resources, they have been They have been moving $6 billion a year in Brazil, these betting agencies, and they generate a tax collection of $890 billion, but removes $28 billion from the market. So there is a huge negative impact in our economy. And it has also been generating 10 million victims, people that become super indebted, mainly people who earn up until $1,060 a month, and their monthly consumption is $40 a month in betting houses and agencies. And so these bets, this technological advancement and the super indebtedness is giving it a new dimension. And we have some technical mechanisms that have been changing this market. The first one is the dynamic price. So the consumer ends up buying a product, and the price varies depending on where they live, depending on their profile, the price of airline tickets, and certain strategies common frequent users of consumption platforms. They use the VPN to hide their identity because this can impact the prices. Personalized prices, behavioral profiling, what are this person's preferences, what are this person's vulnerabilities, and also the calculations of how this consumer is going to buy something or not. Is he against risks or not? Does he tend to engage in the hiring of products and services that is going to maintain them stuck for a long period of time because they are automatic renewal of these contracts? Many of these mechanisms, they have been detected, and they involve publicity, marketing, telling them, this is urgent, we only have 3 items, run and buy your own. And these are very effective sales offer that are specific. And so one of the important chapters involves the discrimination, the algorithms discrimination, the transparency when it comes to these pieces of information that are used to guide these people, and how difficult it is, of course, for a consumer to demand or require this kind of right, or ask people to protect this right and to file a lawsuit. And so these are abusive practices that practically depend on a monitoring, depend on our work, intense work, observing them, gathering information, demanding transparency from the algorithms. And this is a huge resistance point for the big techs. And they claim that, it's something protected by industrial secrets, but they are deep down in the root of this kind of problem. I could list many other practices, abusive practices, related to this use of the technologies, but I would only like to emphasize 2 points. First of all, in the protection of this kind of abuse of and so we have the Brussels effect, the fact that the legislation of the European Union has been creating a kind of benchmark, an international standard, so that many companies that work at a global level, they have to comply with the Brussels Convention and contract. And this is good news for us, generating some kind of positive regulatory externality for Brazilian people, for Brazilian citizens. Another point I would like to emphasize in my last 3 minutes is the fact that dealing with this kind of problem and dealing with these contracts and the relational contracts that last a long time in these regulated industries, and there is the regulation of these technologies, this has been reopening circumstances that favor the acknowledging of the relational contract theory. I'm very glad to see Justice Nancy Andrighi because she's one of the precursors of the introduction of this parameter for the analysis of these contract relationships and mainly in the healthcare industry, healthcare sector, where you have a continuous and long-term rendering of these services in healthcare. And this is complete and well adjusted to all of these forms of hiring people and also from the digital area. This point, from my perspective, is similar to what Professor Kobayashi and Ninoshino mentioned, and also Anayama that talked about that. And it's interesting. I would like to make a comment about the Japanese experience. This theory was developed with this name in the USA. The greatest drafter of this is Neil, and his theoretical and doctrine was based upon the empirical contracts that are long-lasting, specifically the work of a sociologist, an economist sociologist, that analyzed in a very deep way, the impacts of these long contracts, relational contracts, when it comes to the Japanese automobile industry that started in the 1970s. So the greatest success of the automobile industry came after the British automobile industry went down, the Japanese started going up. So you have the networks that integrate the companies, and they created, in practical terms, a new interrelational relationship. So that's the same idea, And then it was incorporated into the general contract theory that, from my understanding, shares opportunities with us, fruitful opportunities and solutions for us to think about consumer protection. And we have to understand the balance, the contract balance, the idea of good faith, the idea of appropriate, adequate information, and the contract amendment, and these contracts that are regulated by AI, the relational perspective, the dimension that this is a contract. It's not just a single spot-on experience, but it is a relationship that modifies throughout time. As time goes by, is modified, changed, not only by the parties involved, the human parties, but also by the interference of AI. Thank you so much for this opportunity.
Agradeço ao professor, peço desculpas.
Thank you, Professor. I apologize for not having remembered that you had to go first. And okay, safe travels. And when I embraced all of you, I am also embracing you. Yes, if you need to leave now, no problem. Thank you. Outstanding presentation that makes us reflect more and more. We judges, we need the help of everyone, mainly the ones that write about consumer law, so that we can move forward in our rulings, in our sentences, and may our rulings be close to the facts and close to real life. So the digital era changed things in a very profound way. The way that I judge, 50 years ago, the rulings were typed on a typewriter and in a courtroom that sometimes didn't have electricity. Now I would like to pass the floor to my dear friend, Professor Laura Schertel Mendes, and she's going to give her presentation now, and I would like to say that this young lady that I met when she was very young, so it is a professor already, and she has been showing to all of us how young people are helping us, older judges, and to think about modern times, modernity. Your Excellency, the floor is yours. I am not going to read her biography because we all have received it.
Muito bom dia a todas e a todos.
Good morning, everyone. I'd like to start by greeting our dear Justice Nancy Rodriguez, an honor, Justice, to be able to participate in this panel under your chairing it, and at this very important event that is the dialogue between Brazil and Japan. And it's a joy to be able to be here for a second time. I thank Chief Justice Hammond Benjamin for the invitation. Just as I'd also like to share the huge admiration I have for your work, for building the jurisprudence that, together with the STJ colleagues you have done in the Brazilian private law, I was thinking about dignity, especially of the most vulnerable, of the weakest, which is the consumer. I brought here some of the sentences that you issued. And when we're talking about private law in this important seminary, we really owe much to your leadership, as well as the leadership of our dear Chief Justice Hammond Benjamin in the construction of private law that sees the consumer, but also sees the changes and the big challenges that the digital environment brings for the protection and the guarantee of fundamental rights. Here I'd like to share this admiration, which I am sure is shared by this whole great community of researchers and law practitioners. And it's a challenge to do this in 15 minutes. I've been working for the past 20 years with a consumer right. Exactly 20 years ago, I entered the Consumer Defense Department. That was of many of the normative transformations. I had the honor of participating in some normative transformations through which the Brazilian law went through. And myself, as well as a researcher during my master's, as well as my doctorate in Germany, in Berlin, I was able to do a certain academic reflection on these processes through which our legal ordering, especially private law in Brazil, went through. So the reflection I would like to bring today was on the evolution of the rights of the consumer in the digital environment, and especially on how the architecture of private digital law in Brazil was transformed in an impressive way. Some of these changes, some of these challenges.
Seja pela influência, claro, também, né, do famoso efeito Bruxelas.
And with the famous Brussels effect,
por uma jurisprudência muito forte, seja do STJ,
we're really strong of the Supreme Court or the National High Court, and by the legislation itself, and because of the National Congress. And so there's a transformation. There's a very typical of our private law. Be a fan of be it our civil benchmark in 2014 or the changes of the new interpretation of the Internet code, which is a very impressive code change between the intermediaries of the Internet that was done last year and this year by the Supreme Federal Court, and with the new data protection law that became a real, from the moment it has a competency for protection data, but with the regulation of platform in general, we're seeing for the first time that we have an administrative authority that is independent as a regulating agency, but an almost digital agency. I think this shows, in a way, I've already brought kind of a summary of what I was going to say, but how the digital environment and the whole discussion in private law was altered in the past few years. Never thought of having a digital regulator. We did not think that was possible to regulate a digital environment as other sector and systems are regulated. We're thinking about telecommunications, energy, electricity. It wasn't seen this way. Have a digital regulator with these new normative changes. I want to bring a little bit of this vision. And I do this a little bit with the reflection that I bring in my doctorate on what is the role of the autonomy in this new private law that is being changed day by day. And this is why I like this part of the text of Justice Eman Benjamin when he talks about the vulnerability of the consumer and the need to guarantee the formal immaterial defense of the consumer. And I like this expression. I think it's something that is very remarkable, that when we think in personal data protection, the benchmark has always been informative self-determination, the control of people on their data, and autonomy has always had a fundamental role. As you know very well now, in the consumer law, although the freedom of choice is nowadays has always been on the consumer code, we've always focused more thinking in objective good faith and highlighting the vulnerability of the consumer, not always highlighting the need of protection of their autonomy. This was the starting point, in a way, from my doctorate in Germany to understand. And what about when we accept the use terms on the digital platforms? Is there no vulnerability there? Would it not be possible to also control this consent that is given in the same way that we control the consent of the consumer, of all the norms, question of loyalty, good faith, including contract control? So it has something very interesting. That was to think, is this autonomy different from the personality rights or law? So the conclusion, right, is we're talking about the same autonomy, be it a negotiating one, related to its data. The truth is that we can think about the same route, and we can eventually also bring these principles to others. And I think this is another academic thing, where we treat this as a tendency of materializing the data protection, in the sense that we need to look for the consentment every time more that is substantial and not just formal. This was the origin of a discussion that was very theoretical and academic. But I think that we can see ever more in Brazilian law this. The tendency of this seems to have Supreme Federal Court of an idea that we have to search substantial autonomy as well, beyond the autonomy of a consentment that is merely formal. And I think this is what joins consumer protection, as well the digital laws and rights that are protected and guaranteed in the laws, be the general data protection or the new interpretation of the Internet Code. As you all know, we have a consumer protection that is anchored in the federal constitution, with all the founding and the principle of vulnerability, have a series of basic rights for the consumer, and we also have some of the most modern dispositions for data protection in the online media. And we have wonderful words from Chief Justice Benjamin explaining how this was done of Article 43 and 44. So we have the first data protection rules of the consumer in this CDC. And so I want to bring this normative evolution of digital rights in Brazil. This starts in 1990 with the CDC, the Consumer Protection Code. Another great benchmark is the civil benchmark for the internet, that was recognized as the Internet Constitution in Brazil, so to speak, which brings a series of rights related to transparency, to the contractual use terms of use, and it also brought a pillar of a rather broad exemption of the responsibility of digital platforms. A pillar that, in a way, I think was important on the one hand, so that the platforms not necessarily constantly respond for content of third parties, and therefore wouldn't stop the evolution of this technology, but was clearly interpreted in too broad a way for too long. And it seems to me that the decision of 2025 that were judged this year, actually, and I think was a correct decision of the Supreme Federal Court to understand that not all the fundamental rights, that the civil benchmark norm was not protecting all fundamental rules. It was protecting the freedom of speech, but when the norm was saying the platform can omit itself and not remove content, even when it is aware of there being crimes or illicit acts, the Supreme Federal Court understood that this norm was partially unconstitutional. Because if you know there are crimes and illicits, you must, of course, there must be a duty of acting and removing this contact. So I think it's very clear nowadays that the norm was allowing omission and that this omission was declared unconstitutional. And I think a very recent thing in Brazilian law, as you see, the decision was from last year. It already brought a change this year that was quite big. First of all, we can't say that there isn't any more an exemption of responsibility by the platforms. It exists, but it's partial, especially because the decision understood that when we're talking about honor and the violation connected to honor, Article 19 continues being applicable because the platform might not know how badly or how much how illegal this content is, and that for all the other crimes, you have the notice and action notice and take down that values, which is the logic of Article 21 that is already foreseen in the Internet Civil Benchmark. And I think it's a big challenge here, the implementation for the STJ, be it this new interpretation of the Civil Benchmark or the new decrees, be it Decree 8771 that was already regulating the Civil Benchmark and now brings a whole logic in platform regulation to this decree, be it a decree on women that is also a platform regulation geared towards the prevention and fighting digital misogyny. I think it's a big challenge to understand how the STJ is going to implement this whole new reality. And there's a very important point here. And I believe we're going to have to read the Civil Responsibility Act differently because, in a way, the decision of the Supreme Court is something much more systemic and collective. When they say that you cannot have certain contents related to crimes, for example, against children, against women, against minorities, they're not saying that not one single content is allowed. What it is saying is that I need there to be care. The platforms must pay attention, take care of this in a systemic way. And it's important because the civil responsibility mechanism is of individual responsibility. So now, reaching the end of my presentation, I think the big challenge is to also manage to get in the evolution of private law and the transformation of private law to, especially first, to have this actual realization of rights, Could you put my presentation back, please?
A minha apresentação anterior. Ah, perfeito. Eu não estava conseguindo mexer nela.
And I think that especially the big challenge, thinking in the evolution and transformation of private law, is to bring this systemic rationale, and that is preventive, that belongs to the digital world. And when we think about consumer rights, it's clear that we need a new logic. It's not for nothing that we need a digital regulating agency, and it is interesting that the convergence between the consumer right and the data protection law, when you think about material autonomy, when you think of vulnerability, when you think about trust and good faith, we have a convergence, a logic convergence that is great, but I have no doubt that we must think on new instruments, new tools. And here, I wasn't even able to talk about all the sentencings and decisions, but I'm sure I'll have other chances to talk about that. I brought some really important reasons here, including the last one, that you yourself validate and confirm the automated revision, especially of excluded drivers in apps such as Uber, for example. So I think we have very important lessons here at the STJ that deserve a detailed study. But I would like to finish, since my time's running out, on the tendency of the realization of private autonomy. And it's interesting to think about this realization with a logic of more substantial autonomy. If we're thinking or talking about the digital world, the famous Lawrence Leslie sentence where the code is the law. And I think the sentence can be updated now, especially because what he's saying is, if the contracts regulated this themselves for consumers, now it's the code, the architecture of the code that regulates, and it controls my ability to consent and have autonomy. Because if I'm not able to exclude or remove or get out of a profile on Facebook, what is the point of my freedom of choice? Be it in one code or the other code, civil code or the consumer code. Now think about Amazon. If I cannot lend a book to someone from Amazon, for example, for a brother to a brother or a family member, then what is the point of being allowed property that is foreseen in the civil code? So here it's clear that the code has the power to regulate that is impressive. And even more so, when we're thinking about AI, we're talking here not just of the regulation of the code itself, but of decisions being made from regulations that were not established by the state. So we have a series of challenges here, and I think that Brazil, with the new interpretation of the Internet Act, Civil Act, and with a more effective power, someone must be able to have this perspective, this systemic perspective. And with that, we would surely manage to realize and have a greater, more substantial autonomy. Now, reaching the challenges to conclude, we must look much more to a risk governance, and now we're looking at the digital ECA, reports on algorithmic impact, reports on impact on privacy, reports or the idea that they must be able to access information about the platforms. The sixth challenge here is about observability and monitoring, where they say, if I cannot see what is being circulating within the platforms, if I cannot understand the amplification mechanisms, why do some contents become viral and others not? If I can't see that, I can't regulate, and I can't regulate what I can't observe. And the big challenge nowadays is to bring and build these observational instruments or tools. And it's a trivial and very difficult one to implement, which is the one to make sure that researchers actually have access to what is in platforms. Although there are some mechanisms already, I think it's one of the hardest ones, and I've still not seen one truly being put into practice in Brazil. So I believe that we need more systemic mechanisms that also look at risk itself, that manage truly protect autonomy in a substantial way, that can somehow also regulate the code itself. And then we have discussion on how to bring the law or how ensure that our normative principles and our rules be respected and put in the code itself. When the Digital ECA, the Act, brings the age verification, that's it. Is to ensure that the code brings the norm itself. And there's an important point here, that is to bring dialogue mechanism for co-regulation.
Our research group, talking about another field that is also correlated, we proposed to the electoral court a new mechanism because they didn't have any mechanism to regulate the platforms, and a mechanism that was incorporated by the last ordinance published by Justice Cássio, which was the compliance plan. We already had rules from the electoral court, the superior electoral court, but the rule was not changed. Are the big techs and the platforms following any of the rules? And the last ordinance published last week says the platforms must hand us a compliance plan so that they can tell us what they are doing. And so we have new ways, new instruments, and I'm sure Justice Nancy that the STJ is going to continue being the main stakeholder to interpret these rules and regulations, and also the creation of new rights so that we can continue implementing and ensuring people's fundamental rights when facing such a modified social reality. I'm sorry that I went a little bit over my time. Thank you for the invitation.
Eu agradeço sobremaneira.
Thank you very, very much. This wonderful, fantastic presentation that we have just heard. And we could stay here for many, many hours listening to such detailed information and also deep information. Now I would like to invite Professor Michio Maeda for her presentation. She teaches Latin American law at the Keio University Law School, and during her PhD, she spent 2 years as an exchange student in the law school here at the University of São Paulo. Her research is focused on consumer law from a comparative perspective between Latin American nations and mainly Brazil and Japan. So, Your Excellency, Professor Maeda, the floor is yours. It's a great honor and joy to have you here. Good morning. My name is Michio Maeda. I teach at Keio University, and I focus on consumer law and compared law, focus on Latin America. I was born and I grew up in Japan, but as Justice Nancy mentioned, I lived in São Paulo for 2 years as an exchange student, and I took my doctorate course there at USP. And it's a great honor for this opportunity, and I would like to really, really thank the Chief Justice, Herman Benjamin, Justice Nancy Andrighi, and all of my friends and co-workers who are present here today. The word dark patterns was introduced in 2010 by Harry Brignall, a British designer who worked at UX. And so they talk about accessibility, visual design, functions of the interface, users, okay, and the impact of the product. And the international initiative to take care of dark commercial patterns was adopted by the OECD in 2022. And the name of this initiative is Dark Commercial Patterns. In this report, the 7 kinds of manipulation standards, all of them were created to force the users to make decisions against their own will. They are forced action, interface interference, nagging, constant interruption, obstruction, sneaking, social proof, and false social proof and false urgency. I'm going to skip a few slides so that we can go back to the time allotted to us on this panel. Besides the report I have just mentioned, there are other dark patterns from the EU and from the USA, starting in 2022, okay? This dark patterns phenomenon can be subdivided into asymmetrical information and also repression to our will to be able to choose. So the false urgency and false social proof, false urgency, and also interface interference, obscure cost, nagging, sneaking, publicity and marketing that makes people make mistakes, force action. And so you also have mini coercion, limitation of people's civil rights, consumer rights. Some of these actions can be considered as false publicity, false marketing, but none of them fit into the traditional modalities. And there are no rules of publicity and marketing. We have some abusive actions, and this is protected by the Brazilian and the Japanese legislation. Now we're going to explore some Japanese cases. The first one is via Gogo, that happened in 2019. This is a website that sells tickets. The problem was revealed by consumer complaints. And also the consumer protection agencies from each municipality and the National Center for Consumer Topics. These centers, they are similar to the PROCON that we have in Brazil, the Consumer Protection Agency, but they don't apply administrative sanctions. And so they receive complaints from Japanese consumers, and they do arbitration between the companies and the victims. And they analyze the complaints and they warn the consumers. According to the complaints received from this via Gogo, they didn't know it was a ticket selling agency. They thought they were buying these tickets directly from the official organizers of the event. So the website seemed to be the official website because of the design and the interface with the user. When they noticed it was not the official website, they wanted to cancel the purchase of tickets, but the cancellation was not accepted. Besides that, on the website, there were many pop-ups talking about false urgency, false social proof, and the consumers, they felt pressured to buy very quickly before being heard. And so we have the Senacon, the Japanese Senacon. We have security, consumer security agency. They said that the consumers, they should be careful with false information or fake information. We have other cases that are very, very interesting, but I'm going to skip a few of them. This is also false advertising. And so they fit into this modality. We have another example here. It's very similar, a similar case. And this is also a similar case. And I'm going to explain this case here. It's another case. It's false advertising about a personal training gym that attracted the consumers with false advertising. And there was only a short period of time for them not to need to pay the entrance fee or the subscription fee. So if they wanted to have experimental classes, free classes, and then the gym made the commitment analyzed by the consumer agency for not advertising the false advertising. They made the gym pay back the subscription fee, and also the commitment. It was analyzed by the public agencies. It's a new system that was introduced in 2023. In the cases of breach of the antitrust law and the breach of the fake representation, it is similar to the conduct adjustment law that we have here in Brazil. When a company makes a commitment, they are exempt from receiving administrative sanctions. So what happens in the cases in Japan? So they are trying to analyze the obscure or the dark patterns using the existing legislation, and the European countries are choosing the same pathway as Japan. And the EU is trying to establish its own global rules, such as regulation of digital services, regulation of digital markets, etc. Article 25 of the Online Interface Design and Organization from the Digital Services Act, these platforms cannot harm the capacity of the consumer of making free decisions and informed decisions. Differently from the European model, the rule that I have just mentioned that imposes strict and heavy rules and immediate sanctions, the Japanese law of the improvement of transparency and equity among the digital platforms that was enacted in 2020 established an innovative regulatory rule among the big techs and their commercial partners. The government only defines general guidelines and transparency objectives, and the platforms themselves, they create their own internal mechanisms to comply with the law. The main focus of the law is to promote a dialogue between the regulatory agency and the digital platforms, encouraging good practices, and they should do this in a voluntary manner. In the traditional model, the average consumer, we analyze this average consumer behavior. So it is a regular person, usually aware of things around them, with common sense, and there is another model that is the hyper-vulnerable consumer, that maybe they are people with disabilities, the elderly, teenagers. But for the digital economy, even experts in consumer law, they can become a victim impacted by these dark patterns. Within the scenario, the vulnerability of the consumer cannot be assessed by the average consumer. It is a situation of vulnerability caused by the interface's architecture. It is a vulnerability. It is a vulnerability that is more psychological, dependence, paying attention to something that was created artificially, and sometimes it was created by AI. The consumer cannot stop surfing or swipe to the right or to the left. So the concept of consumption relationship should be regulated. The consumers, they use platforms in a free way, but in fact, it's not truly free. We supply personal data to register ourselves as clients, and these personal data, they have an economic value. And there is a huge amount of information on the internet. And the times that the users spend online, sometimes the time that they have to make a decision is very limited. And the time of the users also have an economic value. And the consumers, they receive exciting content. In this economic model, an analysis of the user's behavior, and the platforms use AI, and they produce a lot of data, and they use everything they can to attract the user's attention for a long time. So the consumption relationship, it's not only exchanging money for services or products. You have to analyze also the exchange of time and to analyze the people who feel that they are surfing on the internet for free. People, they hand their minutes and their concentration, and in exchange, they receive video, social media without paying direct money. The companies, they capture these people's focuses and they sell this time to brands, famous brands. Thank you so much for your attention. Arigatou gozaimashita.
Eu agradeço a professora Maeda.
Thank you so much, Professor Maeda, for this important presentation, sharing this important comparison with us and the evolution of consumer law, both in Japan as well as in Brazil. Now I would like to invite Professor Takuya Hata for his presentation. He has a degree from the University of Tokyo. He has a degree in law, and he is a professor at Kobe University now. His main research area is civil procedural law, and he has published many, many papers and books. I would like to pass the floor to you, Professor Hata.
Thank you very much for the presentation. Hello, nice to meet you. I am Takuya Hata, as has been presented, a professor of civil procedural law at Kobe University, Japan. In my presentation, I would like to focus on the treatment of identity in the context of civil procedure. Identity plays a very important role in the guarantee of the right to fair trial, which is a constitutional value in most countries. I will talk about the newly introduced institution in the Japanese civil procedure that allows parties to pursue a lawsuit with concealed identity. We will see how the concealment of the identity would affect this right to fair trial. This is the order in which I'm going to give my talk. I will briefly touch upon the meaning of identity in civil lawsuit in general, and then move on to explain the Japanese new institution in sections 2 and 3, and after briefly making an international comparison in section 4, I will show some examples of possible uses of this institution in section 5, and lastly, I will make some evaluation in section 6. First, let me look at the meaning of the identification of the parties in a civil lawsuit. Firstly, identification of the plaintiff has two meanings. One is for the court to know who to treat as a plaintiff. The second is for the defendant to know from whom he is under attack of his lawsuit. The defense by the defendant may differ according to who the plaintiff is, and so knowing who the plaintiff is essential for the guarantee of the right to defense, which is included in the right to fair trial of the defendant. Identification of the defendant also has two meanings. One is for the court to know who to treat as a defendant. The complaint is served to this person, and so this person is guaranteed the opportunity to take part in the lawsuit. The second is to clarify who is bound by the sentence as a result of the lawsuit. And this identification, and identifying who the plaintiff and the defendant are, is done by the plaintiff upon filing a lawsuit in Japan, and I believe in other countries, including Brazil as well. In Japan, up until now, the plaintiff has been expected to identify the parties by the address and the name of the person. The plaintiff has to specify them in the complaint. But in the digitalized society, many transactions take place on the digital platform where actors, including consumers, use IDs which are unique to the platform. There are often cases in which the actors only know each other by these IDs. This fact raises a question as to whether it should be kept mandatory to identify the parties to a civil lawsuit by their names and addresses. This further raises two questions. The first one is whether or not the plaintiff should be allowed to file a lawsuit without identifying the defendant with his or her name and address when there is good enough excuse to do so. The second question is whether or not the parties, both the plaintiff and the defendant, should be able to pursue a lawsuit without revealing their name and address when there is good enough excuse to do so. Due to time restriction, my presentation will focus on the latter problem, and we'll see the meaning of identity in this context through analyzing the Japanese new institution to allow parties to pursue lawsuit with concealed identity. This new institution allows both the defendant and the plaintiff to conceal their identity, but let me focus on the concealment of the identity of the plaintiff. Also, I referred to the digital platform to explain the change of the meaning of identity. I did that, and the new institution and my presentation from now on mainly focus on cases in which parties had physical contact with each other. Now, let me start with the purpose of the Japanese new institution. Suppose a victim of domestic violence wants to file a lawsuit for damages or for divorce against the assailant. Suppose that the assailant will know, currently does not know the address of the victim. Normally, if the lawsuit is filed, the assailant will know the address of the plaintiff, the victim, because the plaintiff must write his or her name and address on the complaint. The complaint is handed into the court, and the court serves it to the defendant. The complaint also constitutes a part of the case record to which the defendant and also a third party, in principle, any third party has complete access. Through this, the defendant and a third party shall know the name and address of the plaintiff. Therefore, cases occur in which the victim gives up filing the lawsuit in fear that she would get assaulted by the assailant if her address were revealed to the assailant through the lawsuit. There are cases in which a victim of a sexual crime wants to hide even her name. To counter these problems, an institution to allow parties to pursue lawsuit with concealed identity, hiding their name and or address, was introduced to the Japanese civil procedure. This was done through the amendment of the Japanese Code of Civil Procedure, JCCP, in May 2022. The amendment went into effect in February 2023. Now let me move on to explain the outline of the institution. The institution consists of the order of concealment and the measures to revoke it. First, I explain the order of concealment. When a person wants to file a lawsuit, but there's a risk that he or she would experience significant hindrance to a social life if his or her name and or address were known to the other party, the person can file a motion for the order of concealment. When filing the motion, he or she must submit a concealment notification form, CNF, in the slide left below, indicating the information to be kept confidential, the name and/or the address. And hereafter, let me call the person who wants to hide his or her name, person in hiding, PHI, in the slide. When a prima facie showing of the requirement, which is a significant hindrance to a social life if the name under the address is exposed, is made, the court issues the order of concealment. In the order, the court decides the concealment of the name under the address and also the substitute information to be put instead of the name under the address on the complaint and other documents. Putting these substitute information on the complaint and other documents shall have a legal effect of putting their name under the address themselves. Under the order of concealment, the person in hiding hands into the court the complaint with the substitute information without the concealed information. The complaint with substitute information is served to the defendant and kept in the case record. The defendant can't know the concealed information. The concealed notification form which contains the information to be hidden, forms part of the case record. But no one except the person in hiding is allowed access to the concealed notification form. So the defendant and the third parties can't know the address, can't know the concealed information. When the order of concealment is issued and the lawsuit is filed under the order, the defendant and the third party are given the measures to revoke such concealment. There are two of such measures. The first one is the order to cancel the concealment. Anyone besides the person in hiding can file the motion for this order on the ground that the requirement for the order of concealment is not met or has become lost. The court must hear the opinion of the person in hiding before giving the decision over the motion. When the requirement to cancel is proven, the court cancels the order of concealment. The second one is the order to permit access. Only the defendant can file a motion for this order, and on the ground that the concealment causes a risk of substantial prejudice to his or her defense. The court must hear the opinion of the person in hiding before giving the decision over the motion. When a prima facie showing of the facts causing such prejudice is made, the court must issue the order to permit access. Under the order to permit access, the defendant is allowed access to the concealed information, including the concealment notification form. Next, let me make a brief comparison among different legal systems as to whether or not pursuit of lawsuit with concealed identity is allowed. First, United States and Great Britain. In these countries, pursuing a lawsuit concerning both the name and address is allowed under certain conditions. Second, France and Germany. In these countries, pursuing the lawsuit concealing the address is allowed under certain conditions, but concealing the name is not allowed. Next, let me show some examples of possible uses of the Japanese new institution. First one is a case of a victim of domestic violence. I use this example as I explain the purpose of the institution in section 1, the first part, so please remember it. In this case, the address of the plaintiff is the object of concealment. The second example is a case of a sexual crime. Say a person named X claims to be the victim of a forced sexual intercourse by a person named Y, and X wants to file a lawsuit for damages against Y. Y does not know who X is. In this case, both the name and address of the plaintiff is the object of concealment. There could be two possible reasons why Y does not know who X is. A, because it was a street crime, and B, because of multiple possible victims. Y has many female subordinates at its office, including X, and Y can't tell who X is without knowing her name. Y acknowledges having sexual intercourse with some of the subordinates, but he thinks that he always had consent. This is the second example. I move on to the last part, evaluation. I would like to evaluate this new institution at the last of my presentation. Let me start with the problem of the institution. The problem is that the concealment of the name can be detrimental to the defense of the defendant. Please remember the usage example I have just shown you. Case of forced sexual intercourse. X is one of Y's many subordinates. According to Y, he had sex with some of them, but always with consent. This was the example. In this case, if Y knows who X is, who the plaintiff is, he could present the defense to the effect that he had never had such contact with X, or that he did have such contact, but with the consent of X. But such a defense is impossible without knowing who the plaintiff is. There are countermeasures against such harm, which are the order to cancel the concealment and the order to permit access. But they are not enough, because the defendant often needs to take action when he or she receives a complaint. In such cases, revoking the concealment afterwards can be too late. Countermeasures against the problem can also be harmful themselves, because no choice is given to the plaintiff to give up a lawsuit upon the issuance of the orders to revoke the concealment. This means that the plaintiff can start a lawsuit with concealed identity, but there's always risk that identity be revealed afterwards. To sum up, the institution has two problems. One, the concealment of the name of the plaintiff can be detrimental to the defense of the defendant, and the countermeasures against it are not enough. Two, there's a possibility that the concealed identity can be revealed afterwards if the plaintiff files a lawsuit with concealed identity. Can these problems be solved? One solution could be to require the confirmation that the concealment won't affect the right to defense of the defendant at the point of the issuance of the order of concealment. But there's doubt whether such confirmation is possible. Also, even if such confirmation is possible and made, and the order of concealment is given by the court, the risk always remains that the judgment be overruled upon the motions to revoke the concealment. Therefore, it is foreseeable that the operation of this institution by the court is bound to be very, very difficult. What kind of indication can we get from the evaluation? We can see that the court is caught up in a dilemma. On one side, the plaintiff wants to hide identity in order to get the right to fair trial. On the other side, the defendant wants to have identity revealed in order to have his or her right to fair trial. So there's clash of the same right with regard to the revealment of identity. This shows that the advantage and the disadvantage of revealing identity are two sides of the same coin and are inseparable. And it illustrates the significance. It illustrates the significance and the uniqueness in function of identity, and at the same time, the difficulty of the treatment of identity. In the background of this lies the fact that identity functions in two different spheres, the real world and the civil procedure, and that these two functions sometimes coincide and sometimes contradict. Although my presentation didn't directly deal with consumer problems, this analysis should apply to consumer problems, especially in the digital platform where identity plays a key role. Thank you very much for your attention.
Com muita honra, eu comunico a presença aqui.
It is a great honor that I mention the presence of two colleagues of mine here, Justice Sebastião Reis Jr. and Justice Afrânio Vilela, that are also following the presentations of this extremely important event. Thank you very much for being here. And now, we're going to listen to Professor Roberto Carapeto, that is professor of the Law School of Nagoya. He has a practice of his own. He acts also in intellectual property, technology law, and data protection, and currently presides the Permanent Committee on Intellectual Property and Foreign Trade, the AAPPI, the International Association for Intellectual Property Protection. Hand over to Your Excellency. Thank you very much. Ending to the instruction, I'll start with my self-description. My name is Roberto Carapeto. I'm about 179 meters tall, dark hair, black beard, dark eyes. I have a light gray suit, a white shirt, and a green-blue striped tie, which are the Nagoya University colors, where despite the name and the beard, I am part of the staff. Due to time restrictions, I'm not going to present myself furthermore, but I understand that myself, as Professor Daniel Machado, that gave us a fantastic presentation yesterday. We are an example of law practitioners where the legal cooperation that we're fostering this event could possibly help to create even more. whatever the future holds for us. In this sense, I take advantage to thank, in the name of Nancy, Justice Nancy, all the Brazilian authorities, the Japanese colleagues as well, and I wish you all good morning. I must admit that I was very tempted to abandon my presentation to deal about what Professor Ronaldo presented and what Professor Laura Tremaines also said. But I will resist and will give you my presentation as planned, which despite the panel's title, I admit the connection with the topic is quite indirect. Several colleagues commented yesterday about the connection of technology and Japan, and also of challenges, common challenges in the country, and the contrast there is between them. And we also had context on how time is a relevant factor in law studies and their relationships with society. In this brief exposition, I intend to present some points in regards to relevant moments in the history of the patent system in Japan and its relationship with innovation. And thinking of something final for innovation, I try and bring a reflection on how to establish public policies for now and or for the long term. That being said, so I chose for this the pharmaceutical sector for two reasons. First, it allows concentrated enough analysis for the time that we have available, and secondly, because it connects directly with Brazilian discussions that are intensified by the judgings or sentencings of the Supreme Federal Court of 5529 inconstitutionality that declared inconstitutional the single paragraph of Article 40 that assured the patents for 10 years from when they were conceded. After this sentencing, we had an intense discussion on this subject in Brazil, involving several cases that are going through that, bringing the focus to the question of patents in the pharmaceutical industry. Before we go on to the pharmaceutical sector, it's important to highlight that the situation of patents in Japanese innovation. In Japan in general, it's possible to say the patents are not dealt just as a private law title. They are an explicit part of the Japanese strategy for technological development. I could spend lots of time giving many examples, but there's not enough time. I could cite the Basic Law of Intellectual Property of Japan of 2002 that links the creation to protection and the use of intellectual assets in competitivity for Japanese economic development. Aside from the existence of several government organizations within the Prime Minister's cabinet itself that integrates the patent system as a central or irrelevant element of public policy systems, especially the innovation ones. So, the Japanese patent system works as part of the innovation infrastructure, jointly with research, financing, and industrial policy regulation. I must admit that, well, I wanted to give a brief historical context. Until 1975, Japan would not allow patent protection for chemical substances and pharmaceutical products, such as we did not used to do it until promoting the industrial intellectual property one in 96. And I want to say also that Japan has been developing since 61 a universal health coverage within its proportions, of course, similar to the SUS in Brazil, but different in the sense that they operate within a co-payment system where the government covers a great part of costs with pharmaceutical products. And so there's a great convergence in these challenges, including in current Japan and the past Japan and in Brazil. So before 1975, the Japanese legal system would allow that pharmaceutical industry, the domestic one, study foreign medication and do reverse engineering and develop alternative process for pharmaceutical products. This obviously favored the access to medication and national Japanese production at the time. However, it also made the practice of foreign products copy far more attractive than investment in trying to find new active principles. It might not seem like it, but the comparison is ideal. At the time, there is data that indicate, well, the data that I found, a little bit from 1970, but 1970, the Japanese industry was responsible to supply about 80% of medication that was used domestically, internally in Japan. In 2022, there's data from Pharma that Brazilian national capital companies are already responsible for 81% of the units sold in Brazilian pharmaceutical market. So the comparison is not completely useless. The Brazilian situation is a bit similar to the 70s one in Japan. There's sense in this comparison.
And the Japanese experience suggests that the technological absorption builds an industrial basis, but the innovation of original products requires the adequate and modern protection of them, that besides other instruments, requires the existence of a patent system that is modern within the public policy on innovation and its infrastructure. The Japanese industry at the time acknowledged this limitation. There are previous research when they amended the law of 1975 that about 60% of the pharmaceutical industries at the time, they agreed with the introduction of the patent protection of pharmaceutical components in the patent law in Japan. And it was a bit different from Brazil, that because of the triple agreement, surrendered to that, but only 90% of the pharmaceutical industries, they were against that. No, 9%, pardon me, 9%. So the Patent Act amendment in 1975 changed the logic of the economy of the pharmaceutical companies in Brazil. The commercial exploration of a new product depend upon their own research, licensing agreements, Japanese public policies trying to foster the exchange of technology, as well as an interest of the private sector. So they changed the incentives. However, the strategic matter was how can we create or access new medication so that we can have development and deal with healthcare public policies that existed at that time. Academic studies carried out in the 1990s indicated how these changes also cause reactions in the long run. Japanese companies that were guided to develop new products, they obtained huge gains starting in 1975. On the other hand, those concentrated on improving copies, improved processes, they didn't have comparable gains, mainly after the world of investments that started in the 1990s, and only a few of them continued existing. They were purchased by other companies. So the reform contributed with the expectations and favored the companies that accepted the challenge of this technological improvement. Of course, it doesn't prove separately that innovation happens due to the patent system, but it is considered a relevant factor for the changes that took place in Japan at that time. And the 1975 reform did not stop the changes. Japan also considered clinical data regarding the safety and efficacy of the medication as a regulatory protection during the system that they implemented in 1979 with the re-examination system. And so they analyze the products after they started being traded. It is not a patent issue, but it complements the patents. So it can allow the companies that invest in the development of pharmacological data to have a legal foundation for their investments in this field. And this system, even though it was introduced in 1979, the discussions and the fine-tuning continue up until now. There is a 2021 ruling from the Tokyo court analyzing the scope of this protection compared to what they have in the patent world to avoid double protection and adjust these situations. Another relevant point is that in 1987, they presented a new reform to the patent law that includes the patent term extension. It is a mechanism that allows the extension of the protection patent deadline whenever a period has been proven. There was an administrative delay from the government to obtain the patent as well as to obtain authorizations to sell pharmaceutical products. And it's not an automatic minimum deadline as we had in Article 40, but it was a compensation because of the lost time and effectively due to the lost time. And this topic continues being fine-tuned. We even have rulings from last year from the IP High Court defining the scope, the patent scope within this extended term and doing the fine-tuning of how to do the calculations, what is the adequate, but it is a system that is considered very important for this situation. Another comment about the implementation of what they call the patent linkage. I'm not going to go deep down into this, but it's another mechanism that works with the intersections between many government agencies that are carrying out different analysis in which the patent analysis is a factor among many other factors for the government to work properly and adequately when it comes to the presentation of new drugs into the market and to protect the investments and the innovation. I'm going to skip this slide because I have already talked about the Japanese public health that started in 1961, but I'm only going to conclude my presentation saying that despite the existence of a system, a patent system that brings relevant considerations into the pharmaceutical industry, they have counterbalance systems. You have the regulation of prices, as we have in Brazil with CEMED. You have other issues, compulsory licensing that Japan hasn't done yet, but in Brazil we did it in 1987. You have a system with different instruments that allows us to have these counterbalance mechanisms. It's systems to allow that generic products industries, they can carry out research about medications that are protected, but they have to develop their own data so that they can obtain pharmaceutical registration. It is the counterbalance mechanism when it comes to the term extension during the patent time. And this came from a ruling from the Supreme Court, the Japanese Supreme Court in 1979. My time is up, and to sum up my presentation, I would like to invite you to reflect upon this. It's not a pre-prepared answer. The lack of an adequate patent protection can even facilitate that copies are going to be made available and reach our markets and create access to medication. But at the same time, history has revealed to us that this limits the innovation and the creation of new medication. The Japanese experience shows that protecting pharmaceutical patents is not a monster, and so we can absorb the technology. The creation of copies is important. Brazil already creates 81% of its national demand with national products, but the original research is very, very good. Now, concluding my topic, this is the biggest problem. How can we find a balance between the public policy for our populations to have access to medication without forgetting to create tomorrow's medication that are also very important? Thank you very much.
Encerramos, desembargadora Lide.
So, we would like to conclude the work. I'm talking to the chair now. We have heard outstanding presentations. It has increased our knowledge profoundly, and we have learned so many things that if we hadn't been here, we wouldn't have learned so much. And what an agreeable event, and what an agreeable opportunity. Thank you to all of the speakers on this panel. And I would like to say that it was a Christian charity act to share part of your vast knowledge, the vast knowledge that all of you have. Thank you very much. Now I would like to pass the floor to the chair. Thank you, Justice Nancy. It was an honor to share this panel with you, Justice Nancy Adrighi. You are a benchmark for all of us judges in Brazil, mainly for the female judges in Brazil. It was an honor to have shared this panel. I would like to thank Professor Laura Scherto Mendes, Professor Michio Maeda, Professor Ronaldo Porto Macedo, Professor Takuya Hata, and Professor Roberto Carapeto for your generosity and for having shared your vast knowledge with us. You have vast experience in each area that was shared with us. Thank you very much. And without further ado, I would like to invite to form the following panel. The moderator of the next roundtable, Justice Sebastião Reis Jr. from the Grand Chamber of Criminal Law here at the National High Court of Brazil, Professor Anelisa Bechara, Professor Marilson dos Santos Santana, Professor Rubem Rodrigues Samudio, Professor Aleph Hansen Costa Amin, Professor José Querino Tavares Neto, Professor Cássia M. Nakano Hirai, Professor Kengo Kashima, and Hideaki Umetsu. Thank you very much. We have to stand now behind the panel for the official photo.
Bom dia a todos.
Good morning, ladies and gentlemen. So, moving on with today's event, the main topic of this roundtable, is the future of the legal profession. We're going to have Professor Ana Elisa Bechara, Dean of the Faculty of Law at the University of São Paulo, Professor Marilson dos Santos Santana, Dean of the Federal University of Rio de Janeiro Law School, Professor Rubem Rodrigues Samudio, he's from the Waseda University Faculty of Law in Tokyo, Professor Aleph Hassan Costa Amin, Dean of the Federal University of Pará at the Law School, Professor José Querino Tavares Neto, Dean of the Federal University of the State of Goiás and the Law School there, Professor Cássia Nakano Irai, a professor at the São Paulo Getúlio Vargas Foundation Law School, Dr. Hideaki Umetsu, attorney at law, and Dr. Kengo Kashiwa, also an attorney at law. So each one of you, dear panelists, fellow panelists, is 10 minutes. You're going to have 10 minutes each. And we would like to start by greeting in a special manner Dr. Afânio, and also Mr. Murta, and also Professor Tiago Taluma, who is a dean at the Federal University of Uberlândia. And I love people from Minas Gerais because I was born in Minas Gerais, and we're always saying that people from Minas are wonderful. So I would like to pass the floor to Professor Ana Elisa Bechara, Dean of the Faculty of Law at the University of São Paulo, USP.
Professora, estão me sabotando aqui com o seu currículo, não está aqui. Ah, está aqui embaixo. Né? Ela é professora titular de Direito Penal.
Professor on penal law. He directs in ethnical and racial questions in the University of São Paulo. He was a researcher at Max Planck and the University of Bonn, and also the University of Salamanca, where he was a visiting professor since 2011. Develops research on legal and corruption, gender, and money. So, Professor, on to you. Good morning to all those present here with us. I'd like to greet especially our Justice Sebastião Rey Jr., our moderator, and to thank in his name all and congratulate all for this initiative. I'd like to greet my panelists, dear justices present here, Brazilian and Japanese authorities here, professors, and all the professionals, dear peers and colleagues. It's an honor to participate in this event representing the School of Law at the University of São Paulo, and I say that although Brazil and Japan are separated by a considerable distance, we share many concerns, especially a fundamental conviction that law can only ensure its mission when it can respond efficiently and in a responsible and intelligent manner to the transformations through which our society has been going through. This last panel of the morning, by the way, is a panel where I think we're probably going to share doubts more than statements or truths. This is the great question, isn't it? What is the future of legal professions? And of course, I'm going to speak here from the vision of a manager of a Brazilian public university, which is that of São Paulo, and also as the manager of one of the first law schools, actually the first law school along with that of Recife in Brazil. And then, so I say that the future of legal professions depend foremost on the type of society that we want to build. And this brings me to our bicentennial history. Professor Kazuo Professor Nasato Ninomiya, two great professors of the School of Law of São Paulo that I greet today. So when the law courses were created in 1927 in Brazil, they were created not just to teach how to apply law, they were created with a specific vocation, which is of building a country. Brazil, that had recently conquered its political independence and that needed to get something even harder, which was its intellectual independence. So it was necessary to build the capacity of people to think of Brazil as a country. So it's important that we build up our magistrates, our public administrators, our diplomats to create an intellectual elite to be able to face our concrete issues of a state that was being born. So when you speak about law and law courses in Brazil, they are born with this deep practical mission, not to produce a enclosed right, but to have people capable of transforming reality. And it seems to me, Professor Kazu, that almost 200 years later, our mission needs to be the same. What changed in truth is the nature of the issues. And so for very long, the big transformation, I believe, of the legal professions happened within law itself. So the constitutions changed, the laws, the codes, jurisprudence. And so today, perhaps for the first time after the Industrial Revolution, our main transformation comes from outside, from technology, in particular from artificial intelligence that has already been the subject of many interventions in these past 2 days. And so, of course, I think there's no more point as discussing whether the AI is going to substitute certain legal practices. That is already taking place. We now have research on jurisprudence in seconds, AI that maps the best strategies in cases of contracts, as we saw here, that organizes proof, that organizes minutes of decisions, and that automates tasks that used to consume hours or even days of work. And of course, with this technology, we reduce time, cost, and labor. Aside from making the access to information more democratic as well. And so we're living through a technological revolution that already produces very practical consequences within professions, legal professions. We see, for example, from the data that the amount of law interns has decreased drastically, as well as the amount of professionals in several sectors, especially in private market. And I think this is something that is very visible, and this makes us think what to do and where to go. And it's important to say that if technology broadens our capacities, it does not substitute our choices. And that's where we have the difficult questions starting. That while we celebrate the advances that are given to us thanks to this digital world, we also live with some consequences that rarely appear in discussions when we're in these events dealing about innovation. For example, with so much available information, as a paradox, we have more difficulty to build knowledge. We're more isolated, more individualist, more intolerant. The networks and artificial intelligence end up favoring, if badly applied, superficiality, favoring a polarization, favoring more immediate reactions, and that have less dialogue. So when we substitute the work by machines without care, we delegate our capacity of reflection. And with that, we lose cognitive capacity of communicating, of writing, and the less capacity for thought. And because we have less tolerance for time of reflection, we are more anxious. We have reduced our capacity of remaining in doubt and reducing our disposition to understand different positions than ours. This has very deep consequences, I believe, because law demands ponderation, discussion, all of this within complex problems. So the risk of AI is not necessarily what they have been doing, but what they are making us used to not doing anymore. And this affects the legal reasoning itself. We already find requests and processes and cases that are written by AI, or even sometimes sentences that are in good part built by AI. So we have AI that is speaking to itself within the justice system. And likewise, Professor Oscar has happened in master's and doctorate dissertations, all produced with a lot more efficiency and speed. But the question that remains within this scenario is, who's going to produce the next great legal theory? How is law going to evolve? Who's going to change the fundamental understanding? Who's going to build the next civil responsibility theory or develop legal categories that still don't exist to answer to the new challenges from society? How does right evolve with AI speaking to itself? None of these answers is going to be solved with the repetition of statistical knowledge already produced. All legal innovation that we've learned like this is born when someone breaks the limits of the existing way of thinking. And breaking limits, it continues being an experience that's profoundly human. Material progress and law depends, therefore, of that's something no one has imagined yet, as Professor Kazuo has always done and teaches even still nowadays. And this is why I'm concerned, particularly with the disappearance of legal professions. Of course, I said we have less interns, less certain professionals, but we also have the appearance of new professions within technology applied to law. The professional's profile for law has changed. Whichever area we look at, the good profession for law is not that one that has a great capacity of storing knowledge anymore. And that used to be characteristic of that of the 20th century or in the beginning of 21st century. The great jurist was able to have a lot of knowledge. That is no longer the case, is no longer necessary. Because this capacity of storage, information storage, is now exterior. What concerns us now is the disappearance of legal creativity. And this is the profile we must look for when we talk and think of the new legal professions. And that may be why the universities, and I'm talking with university directors or university deans, that they are facing their greatest challenge. We're often seen as a privileged place for knowledge production, those who want to learn how to go to the university. It depended on the professors, the libraries, the books. This world no longer exists. Nowadays, any student can go to the room, to a classroom, having lots of information, which is more than what previous generations would have to put together throughout a whole life of study. This does not mean universities need to disappear, but they require a transformation. Our mission, our role is different. Teaching to think, to select information critically, and formulating new questions, questions that do not have answers yet. And then we have the role of the teacher that also changes. There has to be a thought building creation thoughts from and through in uncertainty. This might be the most important legal capacity in the 21st century. Of course, technical knowledge continues being indispensable. I always say this to my students, but I need that which no technology can produce, which imagination, prudence, sensitivity. This makes the strategic value increase in for magistrates, in the attorneys. They must be able to read silence, identify vulnerabilities, and especially to notice the concrete effects of the decisions on life, for human life. These are the great characteristics of the legal professions in the future. And I'll end here. The more sophisticated the machines are, more human the legal decisions will need to be. That is the only way we will be able to evolve. And we used to say, well, you normally say, law is not just a profession, it's a public responsibility. I think that's what's at play here. Of course, we've been discussing this for over 200 years, and as I said, the issues, the problems have changed in these 200 years. The tools that are available to us have also changed, but the original question remains the same for 200 years. What kind of society do we want to build? And I think for as long as we have this question, there will be a place for law practitioners, law practitioners that think. I've gone beyond my time, so I thank you for your attention. I thank you, Professor. I think by coincidence, this weekend I was talking about this subject on AI, and this habit we have of now no one memorizes things anymore. No one memorizes phone numbers, for example. We know it's all on the cell phone. Is that very soon we're going to have a gym? We have gyms to train our body. We're soon going to have gyms to train our brain. The brain atrophies. If we do not create a way of exercising it, we really are going to go for a kind of even devolution. I'm going to hand over now. Marilson Santana from the Federal University of Rio de Janeiro. He's a joint professor in civil procedural cases in defense of minorities. He coordinates the nucleus of mediation and conciliation of the FND, which is the Rio de Janeiro Federal University. He's part of the legal practices nucleus, contributing for practical and strengthening of democratic access to justice. Professor, on to you. 10 minutes. Thank you, Justice, Excellencies, justices, lawyers, members of the prosecutor's office, and members here present. Allow me to first start by thank you for the invitation to participate in the roundtable at this Congress, Brazil-Japan on law, that is done in one of the greatest courts in the country. It's a joy and a responsibility to share reflections on the future of the legal practices with such illustrious people present here. Costa de Miranda, one of the most illustrious jurists, affirmed, "Those who know only law do not know law." This sentence was already provocative at its time, is even more currently applicable nowadays. Law, isolated in its dogma, is not enough to face contemporary challenges. The complex society in which we live demands that legal practice in its unit be expanded. Not enough to just have a theory of decision was developed as well, a theory of conflict. Conflict in its social, economic, psychological dimension cannot be seen just as something to be solved by judges, but as a phenomenon that demands an interdisciplinary analysis. In this sense, there's a robust theory on conflict already. Co-actors of Haring-Dov that offer consistent fundamentals to understand the conflictive dynamic. These theories do not need to be reinvented, but incorporated in the curriculum of the schools of law, so that future professionals be able to understand conflict in its complexity and choose in a fundamental-based way the most adequate ways to solve it. Practice shows that entrepreneurial disputes, collective conflicts on work, including community ones on urban space and environmental resources, can be better understood when enlightened by these theories. Arbitrage, mediation, dispute boards are not alternatives to jurisdiction, but adequate for the study and knowledge of the conflict, revealing that right needs to dialogue with the multiple kinds of composition. Here, theory and practice must be seen as allies. Theory gives the analytical framework, whereas practice reveals concrete responses to conflicts. Another point that merits reflection is the use of artificial intelligence in legal practices. Algorithms already help magistrates in triage of cases and even in creating decision minutes. This forces us to think in a decision theory that incorporates technology without abdicating from the human dimension of jurisdiction. The machine can help efficiency, but not substitute ethical responsibility, sensitivity, and prudence that characterizes the act of sentencing and judging. Here, theory and practice cannot be divorced either. We must understand theoretically the limits and risks of artificial intelligence, but also practice its responsible use in the day-to-day life of legal practices. It's essential that there be existence of professors, lawyers, members of prosecutors' office, and magistrates that are part of this panel and that are in this room. Each of these actors have an essential role in justice and building the future of legal practices. Allow me to justify what I'm saying, but underlying the role of the judge. We're reunited into one of the biggest courts of the country, the STJ, the National High Court, where the act of judging that establishes in a most acute way in the tension between technique, ethics, and democracy.
Besides that, allow me to mention we have an example of federal judge Igor Lazari, a former student of ours. He talks about jurisdiction and AI. He exemplifies how the judges can talk with the academia and also to see the democratic impacts of AI and technologies. It doesn't minimize the other legal professions, but I only have 10 minutes, so I cannot go deep into this. So the future of the legal profession forces us to go beyond the techniques. We need professionals who are capable of understanding the conflicts and the problems. And we have to have a critical dialogue with the dialogues. Pontes de Miranda was correct. Those who only know the law, they don't know anything. But those who know the law and dominate this theory, and those who know the law and integrate the practice and the theory together, these are going to be ready to offer a better jurisdiction in the future. Thank you so much. I made my speech in 4 minutes because I cannot speak longer than that. Thank you so much. Thank you very much, Professor Marilson. Your Excellency talked very well. The legal professional now cannot limit itself to only knowing the law. They need to be open to dialogues, and there is something else that I would like to say and share with you, and something that is essential. The law professional, they also need to know about life. They need to leave their bubble, and they cannot limit themselves to their own reality, their community, only my community inside a court, only my co-workers, only my other fellow professors. They need to find and discover new environments that are not only part of their day-to-day life, and then they can become a more complete professional. Thank you, Professor Marilson. Let's pass the floor to Professor Rubem Rodrigues Samudio. He got his law degree from the Panama University. He has a monography on compared law, and he studied in Panama and in Japan. After concluding his master's and doctorate from the Hokkaido University, he was appointed as a joint professor, and he's a joint professor at the Waseda University, focused mainly on compared law and talking about smart societies. He's also a consultant. He was also a consultant, and he was a consultant for the Japanese government. And he also studies information technology.
Okay. First, I would like to thank the National High Court of Brazil for the invitation and all the professors here. I'm going to speak in English. Second, I would like to apologize because my voice is about to give up. So I will do my best to end this presentation. Third, I'll finish on time, don't worry. So we have a lot of professors and judges here and lawyers that I would like to try to deviate the conversation a little bit about the future of the legal profession and focus on the citizens and the judiciary. And in regards to that, if we really think about this work was supported by Kakenhi, I need to say that as part of the whole deal. So if we really think about that, of the three branches, citizens have the less contact with the judiciary. Like most of the citizens will never talk to a judge. They don't know who their judges are. They don't know the faces. Pretty much we don't know a normal citizen. Pretty much we do not know the name of a Supreme Court judge in most cases. But in the few cases where judges are elected, tends to be rather political. We have such systems in the United States, in Mexico, was a constitutional amendment 2 years ago. And I think Bolivia is the other one that has a similar system. So if we really think about that, Merriman and Perdomo explains that the judges under the common law system and the civil law system they fulfill different roles. Under the common law, judges tend to be paternal figures. People know what the Supreme Court judges' names are. When there's this big case coming up, CNN and all these news broadcasts will talk about how X judge will vote, how Y judge will vote. They're common names. They tend to also participate a lot in scholarship. Yeah, by contrast, if we go to continental law, Japan, Brazil, Panama, judges are public service members. They're anonymous. Like we here, we're lawyers, we're professors, we know the names of the judges, but if I were to go to the street and ask a normal Brazilian what is the name of the Supreme Court justice, I probably wouldn't know. An average Brazilian, I would assume. I know an average Panamanian wouldn't know. So in that case, judges begin as career civil servants. That's the same in Panama, that's the same in Brazil, that's the same in Japan. For Japan, they pass the bar examination and they finish their judicial training and they start as junior judges. And then after 10 years, they become full-fledged judges. It is not common to become a judge if you don't follow this career path, but it might happen. There is a bengoshi income that you can become a judge if you're a practicing lawyer, but it is not common. If you go, here is the number of judges. There are about over 3,000 judges in Japan. You have the Supreme Court 15, superior judges 8, judges, full-fledged judges 2,000, junior judges about 900, and summary court judges about 800. For our purposes, the Supreme Court has 15 judges. 4 judges, 1 chief judge, and they're appointed by the cabinet, by the emperor for the cabinet advice. Here is the point that I want to make. In Japan, the legislature has no voice, no vote in that. In our countries, in Latin American countries, in continental law countries, it's usually the government that proposes the judges. They go to the legislature has a vote, and they become elected. So in Japan, citizens have no way, indirect way, of actually having a voice about the judges being elected or appointed. Sorry, this is in Spanish. I forgot to change it. So traditionally, the judges come from the judiciary. You have 5 judges, and then you have the other 10 usually tend to be lawyers, prosecutors, public functionaries. Sometimes you have diplomatic functionaries, and you might even have some university professors. The Constitution does allow for the citizens to vote out a Supreme Court judge. There's two problems with that. First, that the election has to be, that vote has to happen in the first election of the House of Representatives, and the second vote after the judge, 10 years after. Most judges are appointed when they're 60. So no judge so far has gone to that second election. And no judge so far has been removed using this system. That's the premise. So what I want to talk about is something that happened this year. In March 2026, a Tokyo lawyer created this site called Saibankan Map, or Judge Map. So what he did is he created a database of all the judges, well, about 2,500 judges throughout Japan. And the users can rate the judges using a star system, just like you have a Google review, whatever. There's also a Bengoshi map. There's also a lawyer's map, but we're not going to talk about that today. So this is the homepage of the main page of the site. It tells you the number of judges. You can look for the judge based on the prefecture and whatever. So according to the site, this site was created to shed light on issues within the judicial system. Because even though the Constitution does allow the removal of a judge by a voting, it is limited to Supreme Court judges, and it's never been used. It's never been effectively used. So here is the problem. Here is the future of the legal profession based on these technologies. We could talk about AI. We talk about how the legal profession is using generative AI to make our job easier. But it can also be used by citizens. So citizens now have a way to say, you know what, this is a smart society. I actually want to have a say on what the judges say. It does bring some problems though. On the one hand, especially in Japan, citizens have almost no control over the judiciary. It is completely out of their hands. And because judges tend to be non-elected officials, they might reach conclusions that the majority of the citizens do not agree with. On the other hand, judges must be neutral. They must apply the law. It's not a popularity contest. So it is a balance that we have to take into consideration. I actually spent some time going through the reviews of these systems, and I came to a lot of issues. First, the problem, or the first issue I realized, is that the users don't really understand the judicial process. So in Brazil, in Panama, in Japan, when there's a criminal case, the prosecutor asks for a certain number of years. I want this person to receive a sentence of 10 years. And the judge or the jury decides how many years the person is actually going to get. But lay people don't understand that. So some people, if you watch the review, some people say, why did this person get 10 years? And then we're talking about the number of years the prosecutor was asking for before the sentence has been handed down. Another issue or phenomenon I saw is that when the case is reported on the news, it gets a lot of reviews. And because if you actually see what the site says, it says that the site provides a platform where individuals who have gone through the judicial proceedings, what you realize is that you have a lot of people actually voting on cases they were not part of. So they just saw the news, they saw this case, they became angry because of whatever they think the judge did, and they reviewed the judge with a 1 star. Another problem is some comments don't even don't even talk about the conduct of the judge. They just try to support the specific outcome. I saw that a lot with sexual harassment cases. So sexual harassment cases, review regarding sexual harassment cases would be like you have one side of the users would say, yeah, I support the victim for coming out and claiming sexual harassment cases, and you have the other side of the case, but there's no proof here. It's only what she said. Why is he getting condemned because of that? So that's not about the conduct of the judge at all. It's just what I believe the standard should be in those cases. I have 10 seconds and to finish. So I started thinking, why does this happen in Japan? Why is this? And I came to realize something quite interesting. So all of you know this. The goddess of justice, Justitia in Roman, and Themis in Greece. I think this is around here, I think. This is the Brazilian one. This is the Japanese one. Did you notice something? No? This is the Supreme Court of Japan. Did you notice something here? Yes. I've seen the statues of the goddess of justice, of Themis in Japan. I've seen in Chuo University, Supreme Court, in lower courts. The statues of the goddess of justice in Japan are not blind. In every single statue I've seen of this in Japan, the goddess is not blind. So I think that's a cultural thing. I think that's interesting that lawyers and citizens say, we do not believe the justice system to be blind. And I think that is a representation of that. For us, justice has to be blind. But when you go to the Supreme Court of Japan and they have this statue of justice just blindly look inside, I think that the judge map is a representation of that. Thank you very much.
Muito obrigado, professor.
Thank you very much, Professor. I believe that we are sharing a common problem. And it's a certain duality, and this is very interesting. You have a judiciary branch that everybody knows who is there. They question us, they exercise pressure. They are the target of compliments or criticism, and you have a more discreet judiciary branch. Nobody has the direct access or open access. Once I was at the American Supreme Court, the U.S. Supreme Court, and during these visits we asked, the cabinets, are the cabinets of the judges in this building? And they said, we have no authorization to answer that question. And so here in Brazil, you have a contract. All of the sessions, the judgments, they are broadcasted live. And so we have round tables discussing what the Supreme Court is doing, what the courts decide. So this is a moment that maybe we should find a balance for that, even to be able to preserve the non-biased nature of the judge. Now we have Professor Aleph Hassan Costa Min. He's the Dean of the Federal University of Pará. He teaches at the law school. He has a degree in law from the Federal University of Pará. He teaches administrative law, and he has research in the areas of administrative law and environmental law. Professor Aleph, the floor is yours. Good morning, ladies and gentlemen. First of all, I would like to greet the panel via Justice Sebastião Reis Jr. I would like to greet the professors, students, Your Excellencies, judges who are here. As Sebastião said, I teach at the Federal University of Pará, and I'm the Dean of the Law School. And just like other universities, it is over 100 years old. We have a history of 126 years old. And it's older than the Federal University. And to talk to you, I brought a reflection. We're going to discuss Nicholas Luma, to think about the law as a closed operational system, but that is cognitively open, so that we can talk about the future of the legal profession based upon law. That's why I chose this topic, that the future of the legal profession goes through the administrative law and also via the environmental law. And I'm going to share my thesis a little further down during my presentation. To sustain the thesis I would like to share with you, we talked a lot about, and even on this panel, about the use of technologies. AI is a recent technology that is dominating the entire field of the legal profession, but a few years ago, we talked about the use of blockchain as a revolution. And why did we say that it was a revolution? Because I have a decentralized system that shares information, validates documents without having a specific data center. And this facilitates the authentication of these documents. It facilitates the sharing of these data. And also it facilitates the changing of certain pieces of data, altering of certain pieces of data. A while ago, people said that blockchain would revolutionize the legal relationships. And this became pertinent because we started talking about the smart contracts. So these smart contracts, they became a reality in our day-to-day lives. And here we have a machine, a vending machine, that is an example of a smart contract. You add your money, the machine recognizes the value, and then it gives you the product. So the purchase and the sale, they are over. And why has blockchain became the technological instrument that would kind of foster this kind of smart contract? Because it allows certain contracts and validations that go beyond a vending machine. For instance, there are some European countries in which you rent a private car and the owner of the car leaves the car there parked. You download the app, you pay with your credit card, you go to the car, scan the QR code, validate your credit card, and the car is released for you to use it during a certain period of time. That's a smart contract. And where do they store these data? Inside the decentralized chain, inside a blockchain. And this is extremely relevant from the legal perspective because I have a legal business. I have a smart contract, a services contract, and it's private. And this technology and this kind of contract, they advanced so much that a few years ago, 5, 6 years ago, we talked about the ODRS, the Online Dispute Resolution mechanism. So if in Brazil I have a platform to buy food on restaurants that is very famous, I buy the food, receive the food at my house. If it's not the same way that I ordered, I take a photo, send it to the platform, the restaurant justifies, they talk about their defense, and the platform decides this conflict.
So either the supplier or the client is right, and that's where it ends. That's what the ODRS would be. And so we spoke a lot of the self-execution of a smart contract because you have a coding, put it in a blockchain, and it self-executes. And I participated in this kind of research where the public administration contracts could also operate through this self-execution model. Supply for water, for materials, that it could be with automated delivery and payment. But this model obviously did not start from lawmakers or from law practitioners because it needs regulation. Here in Brazil, for example, we regulated the virtual assets market to establish a limit. And it's on this point that I want to reach. Whenever a technological evolution appears, we need regulation, be it for ethical, democratic reason. I'm going to go on to this slide, which was the point that we spoke about much here. Artificial intelligence. It substitutes certain work that used to take a lot of time. Personally, my experience, I always liked technology. So as a teenager 20 years ago, I used to build sites on subjects that I liked in 3 to 4 months, programming HTML, etc. 5 years ago, I built a site with some tools in a month. Nowadays, with artificial intelligence, last week, I built it in one day, and it was far better than the one that used to take several months. The platform with no coding, where you don't need to code. So the work that 20 years ago I used to take 4 months, it took less than a day, and it's even better. This is a ridiculous amount of time economy. And within the legal reality, and so this can prepare minutes and decisions, and all this technology advances to debate, it would be that a regulation. I bring principles of environmental law because we start talking until what point can AI reach? What is the limit of its use? What is the democratic limit for its use? In environmental law, we have the principle of precaution. When you not know that risk, you avoid the activity. But here we have a dilemma. It is impossible to stop completely the use of AI because it's a very important tool. Professor Analisi that spoke previously, when you had a lot of knowledge, there was an advantage. There's a professor, Michael Porter, that even won the Economy Nobel Prize. They used to say society previously, when you're talking about Adam Smith and such, it wasn't a comparative advantage, that society that had more resources had more advantages. Now we're talking about competitive advantages. It's not so much the amount of resources, but the quality. So the competitive advantage for the professional is have so much knowledge of the law, but rather how to use the knowledge, how to use these tools. And so you have the need to discuss regulation. So the principle of precaution, can I inhibit the activity? No, but I live in a society in risk. Professor Beck had a really important book for those who are for environmental law, which is Society in Risk, and it talks about the society of contingencies that we live in currently. So we have this necessity to regulate, and then you have administrative law using its regulatory power. 2 examples here: EU of normative documents, in Brazil, the CNJ resolution, and in Japan also something that does not forbid the use of AI, but it's only allowed in certain points.
Esse ponto aqui eu acho muito interessante, mas vou tentar ser breve para chegar no ponto que eu quero.
So our legislation in 2018, the data generation code, it talks about the decision. So I cannot have my decisions on abstract values. I must always ponder the practical consequences of that decision. This is in the law of introduction for Brazilian laws. And for the data protection, we say that the automated decisions should be revised. This is in the use of artificial intelligence, which we didn't even talk about before. This norm is very relevant. Here I have a conclusion of the thesis I want to present. Why the future of legal practices goes through administrative law as well as environmental law. Studies that are very old talk about virtual water. That is a concept that was conceived by an English professor in 1992, where he verified that certain activities have an indirect use of water that we do not notice in our day-to-day life. So, for example, to produce jeans, you need 20 liters of water. To make a dish of pasta, we're talking about 200 liters of water all the way from the farm to the table. So, use this virtual world to bring attention, but it's water that is indirectly used in certain production. And this indirect used water is very important in a geopolitical context. And so what can I produce here? What should I import in order to save water? And this is intimately connected to the use of AI. Because when we're talking about artificial intelligence, we have an indirect consumption to maintain data centers of 150-60 billion liters per year. The UN is projecting that until 2030, this is going to double to 1.2 trillion just for data center maintenance. Well, because of the cooling it needs. This is done with the use of water. So in this small operation, when we enter any app of AI, there is a water consumption that is indirect, being it for a question or because of the profession itself. And what is the relevance for this? We're currently projecting Brazil the construction of 195 data centers, 1/3 in the southeastern region, and the majority of it in the state of São Paulo. The state of São Paulo, once again, this leaves, well, we have this published in newspapers. So how can I have data centers in locations where we already have water stress? This is a fact that must be pondered for decisions related to public policies. I'm bringing here, in Portuguese, recent news related to my city, Belém. Belém was never a center for decisions related to technological entrepreneurial actions. The city culture is another. The services and entrepreneurial industrial are different. So much so that in the state of Pará, we have fishing as the main economic sector related to activities that are undertaken in the state. But because of this whole paradigm shift in the world, we started thinking of implementing data centers. That 10 years ago would be something that no one would have ever thought about, to have an industrial technological center in the city that doesn't have this culture in it until this one. But why? Because the Amazon basin concentrates 12% of all fresh water of the planet. So in this new world of technologies, where you need the use of water resources, the poles start changing. And this is where I have my final question. So how are we going to regulate it? There are 3 frameworks, 3 models we can adopt to regulate this kind of activity. The first one that I'm placing here as a market regulation. Market self-regulation was defended by Harden, the article written in 1968 that might be one of the most cited articles in the whole world, published in the Science magazine that talks about the tragedy of the commons, where we talked about 2 farmers sharing their farmland and how it could be regulated. He says the solution is very much by the market law, because who can pay? Users. Who has the power to purchase it or pay can use it. How can we translate this to our reality? The apps, the artificial intelligence tools work with tokens. So the more tokens you have, the better is the performance of that intelligence. So much so that there are tools that do not demand tokens, and they start hallucinating, bringing wrong information. Why do they bring wrong information? Because their tokens are over. There are others that work until your tokens are allowed. If you don't have them, you cannot use them. By the market laws, you buy and use. But what about those who can't afford to buy it, to use these tokens? And then you have the legal question, because out of using recent information comparing 2025 and 2026, in 2025, we had about 50 to 60% of the lawyers that used AI. Nowadays, it's about 80 to 90%. Now 80 to 90% use this tool. So to use it, you need a token. I'm going to use it, I'm going to regulate it through the laws of the market. Or second possibility, the regulation power. It's with the administrative law. And the third possibility, that I put as a thought, is seeing the resource involved, such as water resources, as common assets or goods. And we have the theory of Professor Ostrom that also won the Nobel Prize, which is the governing the commons. We have institutionality to decide on those resources that cannot be excluded from or by anyone. So we can think of a future regulation, how this is going to directly impact legal professions. I apologize for going over my time. Thank you very much. Thank you very much, Professor Alefi. I think we are facing a reality where we can see how all of it is interconnected. There are no really isolated areas anymore. So when we talk about artificial intelligence, we think it's a technical question, and we see the reflection or the impact this has in the environment. Another question that I have, and I think is interesting, is the fact that the regulation is always running after the transformation. The world is much more creative than the legislator. I say this a lot in penal law, where crime comes from out of nowhere, and suddenly you see you have to create a law. Reality creates, and the legislator runs after it. This is what happens nowadays. I'm going to hand over now to Professor Querini Tavares Neto. He is Dean of the School of Law at the University of Goiás. He's postdoctorate from Coimbra, graduated in Social Sciences and Law, Master in Sociology by the University of Campinas, Doctor in Sociology by the State University of São Paulo, Quinta Filho, Doctorate by the Catholic University of Paraná, Associate Professor of the School of Law of the University of Goiás, and a Professor of the Program in Law and Public Policies at the Federal University of Goiás, Consultant of the attendant University of Paracatu. Please, Professor, on to you, 10 minutes. So I greet everyone here. Justice, Chief Justice, no, I'm promoting you already. I'm sorry, no, please do not cause any confusion for me. In the name of who, I greet all the colleagues here. I give a personal reference to Professor Kazuo Watanabe, who influenced the whole generation in which I'm included. Perhaps you do not remember, but you were always a great influence. So thank you for the invitation to participate in such a relevant event. I greet the STJ, the civil servants here, and the law students here. Ladies and gentlemen, I don't know if we should talk about future. It is already here. Much has been discussed on the impact of artificial intelligence in law, but allow me to start with a brief provocation. I'm ever more convinced that the future of the legal professions will depend less on an AI and more on how we continue teaching our legal students. This dialogue's reflections that I've been studying for quite some time, especially in articles and books. For those that might be interested, they can look for it in both my papers. I sustain that the real challenge for the future for law is before all methodological and epistemological. I would like to share just a few reflections due to time restrictions that I consider essential to think on the future of legal practices. First, we live through a historical time without precedents. There's no doubt that tools such as AI, automation, and data science are modifying the way how we produce, organize, and apply legal knowledge. However, I think that the biggest challenge is not on the use of these tools. Technology transforms the way how we work, optimizes time. But what matters is the method, the way we think, the essence, that is the ontology of things. For that reason, the biggest challenge continues being the training of jurists, not just in Brazil or Japan, but everywhere in the world. From the graduation, the continued training for defense, prosecutors, lawyers, and by the profession that is regulated by the CAPs. And so the correct question is not if AI will substitute lawyers, promoters, prosecutors, magistrates. The question that guides us is different. The question is, who will be prepared to use this technology in a critical manner? That is the fundamental question. And that my previous questions have already dealt and mentioned about this. It depends on the methodological training received throughout the academic and professional life. Those that have academic training with a understanding method, with the big epistemological matrices, see reality differently. As a fundamental point of training and capacity building. It is for this point and on this point that these authors, Pierre Bourdieu and Max Weber, offer a decisive contribution. Scientific knowledge, reaffirmed by these authors, is not produced by a position that is completely neutral. There is no scientific neutrality. Every scientific field organizes its criteria of legitimacy and its perception categories and its means of authority. And the legal field is no exception. The jurist interprets reality based on intellectual categories built throughout his formative years and training, and sometimes even before that. The jurist interprets with that. That is why the method doesn't represent just a step in research, but the way of understanding the world itself. For Max Weber, for Bourdieu, for Foucault, it comes before understanding. More than a group of techniques, it conditions the way how we identify problems, select evidence, build arguments, and produce legal knowledge. Nevertheless, our legal form training is influenced by a structure guided by directives from curriculum, by the institutional evaluation criteria, by, of course, also the bar exam of Brazil. All of these mechanisms have huge relevance, institutional relevance, but end up privileging very often information geared predominantly for the dogmatic teaching of law.
We are training outstanding legal operators, but we need to train more researchers capable of critically understanding the operations of the juridical or legal system. That is the most important reflection performed or developed by the Bourdieu, and also in the studies of Max Weber, mainly economy and society. Third place, trying to answer, what is the future of the legal profession? I don't believe that the legal professions are going to disappear. It's exactly the opposite. I believe they are going to become more and more relevant, and our societies are going to become more and more complex, as mentioned earlier, marked by fast, dynamic technological transformations, economic transformations, environmental transformations. What is going to change is the profile of the legal professionals, okay? Using Pierre Bourdieu and Max Weber again, for a long time, it was enough to know the legislation and the jurisprudence deep down to pass the bar exam, but this is not enough to become a good judge, a good justice, a good prosecutor. The modern judge has to dialogue with the economy, with technology, with sociology, with human rights, with climate change, the social environmental conflicts. And so, unfortunately, I cannot discuss this deeper. And the 1988 Constitution did not set forth completely as it should, but they didn't deal with the socio-economic aspect and also AI. And Edgar Morin has taught us, unfortunately, he has passed away, So learning has become indispensable for us to understand the reality. The jurist is not only an interpreter of the legislation, he has to become an interpreter of the complex world we live in. And so this is acknowledging that the legal field does not produce answers in a separate manner. And it permanently dialogues with the economics, with the media, with international bodies, and also the devastating market. As a consequence, the legal professional needs to understand not only the legislation, but also the social mechanisms in the production field and also the law. And please allow me to conclude with a brief reflection. AI is going to produce answers that are better and better. However, the future of the legal profession is not going to be decided by machines, but by the institutions and also the creators of opinions who are going to use it. The methodology is going to continue being the element that is going to allow the legal experts and the institutions to create the correct questions. And this is what really, really matters. It's precisely this capacity to interpret our reality and to create solutions that are based upon the Constitution that separated the real jurists. That's why the future of the legal profession is not going to be defined only by the technological advances, but mainly by the quality of the training, the intellectual training of our legal scientists, the ethics, the sciences, those who are part of the judiciary. Within this context, institutions such as the National High Court of Brazil, the universities, etc., responsible for the training of our legal experts. They have to play a role that is going to go beyond sharing technical knowledge. We're going to have to create a legal culture, compromise with our constitution, with democracy, with the scientific production, and with a permanent improvement of the legal profession. If we want to prepare the law for the challenges of the 21st century, we have to invest less in the concern. Are the machines going to substitute the legal professionals? And in the training of the jurists who is going to be able to think critically about our society, about institutions, and about the law. Thank you very much.
Professor, muito obrigado.
Thank you very much, Professor. You raised a valid point, an important point. It's becoming clearer and clearer that we need to train those who are going to use AI. They must be aware that AI is not what's going to solve the problems. AI is going to help us solve the problems. This is a matter that has to be made very clear. The final decision has to come from a human. He's going to give the last word. And I believe that we need to think about this. We need to be made aware of this. The people who are entering the job market now, they are learning how to live with the AI. Now I would like to pass the floor to Professor Cássia Nakano Hirai. Professor Cássia is a master in law by the Fordham University. She works at the São Paulo Getúlio Vargas Foundation at their School of Law in São Paulo, and she leads the project called Legal Clinic, and she helps many students. She does a lot of research, and she studied active methodologies. She was a visiting professor at the JICA in the Yokohama University in Japan. Thank you very much. Thank you very much, Justice Sebastião Reis Jr. First of all, I would like to describe myself for those who have any visual impairment. I am a short woman. I am from Asian descent, from Japan. I have dark, short hair. I'm wearing an orange dress with a brown jacket. Thank you so much for the invitation. It's a great honor to be a part of this panel. Thank you. I would like to thank all of you through Chief Justice Hammond Benjamin and Justice Sebastian Jr. I am the deputy coordinator of the Getúlio Vargas Foundation in the state of São Paulo. So most of the time in the work that I do is dedicated to thinking, not only managing the courses, the classes, the professors, the students, but also to reflect about the syllabus, the courses. So my best contribution for this panel is to share with all of you a little bit of how we have been facing these challenges that impact all of us involved in higher education. So in a very brief way and using many images because I do not want to be repetitive, some of the vectors that are demanding from us a transformation of the law courses. So AI, as it couldn't be different, and it has already been mentioned, because AI, mainly the generative AI, they have been changing radically the way the students have been studying, reading, and doing research. Besides that, the value of the diploma. And so the students and the employers and our society, they have been demanding more and more evidence that it's worthwhile getting a higher education diploma, and if this is going to give them a return in their investment. And also professional mobility, social impacts, they are a few indicators of value, value of certain universities and colleges. Accelerated obsolescence of our competencies and skills. Our skills are becoming more and more obsolete and faster. We can get a diploma, we can get a degree, we can get a certificate, and a short while ago, these skills become obsolete and new skills are needed. So we need to constantly update ourselves. And we also have the lifelong learning that we must have. And this has become an imperative for our universities and schools. New and emerging areas. As the previous topic, we are dealing with areas that didn't exist any longer and now they exist, and they have to be incorporated to the higher education courses. As an example, the last syllabus reform we carried out was to insert topics regarding digital law, disciplines, projects, research topics, and for sure, in the training of most of us, this didn't exist. So this shows the need of us having constant updating of our skills and competences. New expectations on the part of the students. Students nowadays, more and more, they require educational experiences that are stimulating, that they can participate in, that are digitally integrated. And once again, the coordinators and the universities, they have to create methods that are going to satisfy or meet this demand and to make the training or the education deeper and more meaningful. We also have to think about the importance of mental health of the students and of the faculty members as well. And the expansion of social expectations about our universities. Nowadays, higher education institutions, they are not measured or judged upon the teaching that they offer, but the people expect from us a role in innovation, in sustainability, in social inclusion, and also in the regional development. So all of this started being part of the packages of objectives of these educational institutions. Before all of this, our main question is, how can the universities keep themselves being relevant? Okay, relevance for individuals, for the students, for the labor market, and for our societies. Some answers that I'm going to share with you, they were generated by our practice at the FGV, the Getúlio Vargas Foundation. So we have an innovation hub at the FGV that unites scholars, researchers, and professors from the FGV to rethink the higher education system. And this report specifically was just published last year, and encompasses 54 papers that discuss the reform of the higher education system. And we also have this part of the ranking of the Times Higher Education that was published in 2025. We have recent publications like the practice from Harvard Law School. It is the most current edition, June, July, and August of this year. And this is a manifesto from the University of Chicago that talks how the School of Law is seeing education when faced with AI. So we have a set of all of this, and our practices offered some highlights. Number one, we need to develop a resilient education, resilient to AI. And the term resilience to AI comes from the manifesto written by the professors from the University of Chicago. And what do they mean by that? We have to think about a training that is going to develop in the students the capacity to learn without AI. And we're talking about cognitive skills that are essential. But we also have to teach them how to learn with AI, because this is unavoidable as soon as they graduate, and we have to teach them how to think about AI. So with, about, and to be resilient to AI. We have to value the competences that are essentially human, everything that machines cannot do for us. We human beings and legal professionals. And here, from the perspective of higher education institutes, we need to create learning spaces that are going to give the students these opportunities, projects, legal clinics, real examples, real practice, so that the students, they can develop their critical thinking, cooperation, teamwork, ethics, responsibility, etc. Another trend identified was the building of integrated institutional ecosystems, as for instance, innovation hubs, technological centers that are going to help all of the schools at this university, sustainability centers, support to students and professors, among other ideas, to integrate the entire institution. But it's going to align the entire institution, and it's going to strengthen the university and the colleges as a whole. We also saw how important it is to have external engagement that is strong. We're talking about the market, of course. And this can happen via career centers, fairs, internship opportunities, connecting the theory to the practice. And in order to have strong external engagement, we need to have the alumni close to our universities. This is important for them to feel that sense of belonging as part of the community, having a dialogue between the theory and the practice, and of course, networks of universities as the one that we have been discussing and that is about to be born. It's another way of having information and data regarding this integration with the external world. This one, we have to measure the impact, not only the activities. We are used to annual reports and they list the activities, but beyond the activities, what were the impacts caused by these activities? Caused on the students, on the institution, for the students. The first measure, that is the first one, have they become employable? And for the institution, we think about social impacts, regional development, as mentioned earlier, among other tools. And due to my limited time, I'm going to skip this. I would like to share a methodology with you that we use at the FGV. to follow up if we are meeting the demands. And the last link of our chart here is permanent assessment and updating. Just as with the competences, things have been changing too quickly. And so the institutional objective that in the past was relevant stopped being relevant. So permanent assessment, permanent updating, redesigning, and this is important to become institutionalized and formalized. And I would like to wrap up by saying that it's been an honor to take part in this event. And I forgot to mention, I would like to thank the support team. They have been working hard and they have been very competent. Arigatou gozaimasu. Professor, it has become clear that we are living in an ever-transforming world, and this world does not allow us to become on our couches, just sitting there accommodated. This presentation is going to become obsolete in the future. New analysis, new situations are going to demand a new position from us. What is enough today is not going to be enough tomorrow. I would like to pass the floor to Dr. Hideaki Umetsu. He's attorney at law, and he works at Mori Yamada Law Firm in New York City. He has vast experience in trade agreements, contracts, mergers, compliance, companies, human rights, commercial compliance. He has also active participation in the creation of public policies, such as the Ministry of the Economy in Japan and also the UN program, the UNDP. He has the position now of co-president at the Bar Association. He was a professor at the School of Law, Seikei. Professor Hideaki, the floor is yours. Thank you, sir. Thank you very much. Good afternoon.
I can say, so I speak in English. And it is my great honor to speak here, and it is my privilege, that I was invited to the Supreme Court Justice's residence and also Ambassador's residence last night, and this is my honor to come here. I have been working for the Japan-Brazilian matter for the last 10, 15 years. I'm a Japanese lawyer. I was based in Japan, but for the last 3 years, I have been working in New York. So at this time, I flew from New York. But this is the first time I come to Brasília. This is such a wonderful, beautiful city. So I'm very lucky to come here. And last night, I learned a very beautiful way of making a toast from Ambassador Noguchi. It's Viva, Sauji, and Kampai, right? I'd like to use that word going forward as well. So with that, I'd like to start, my presentation. But today I'm speaking not as the managing partner of the New York office of my law firm, but rather I'm speaking with the head of IBA. So IBA is the International Bar Association. And as kindly introduced, I have been working for the International Bar Association for the last 10, 15 years. And the International Bar Association is the largest practitioner lawyers group. And we had the commission called Future of Legal Services Commission, so which is clearly, a match this topic, for today. So I'd like to introduce, what we are doing. Basically, what we are doing, actually, we are doing the survey for the Future of Legal Services Commission. And this is available on the website of the IBA, so please take a look at it. And what we have been doing, actually, we are doing the survey for the lawyers or professionals, judges, public servants, all over the world, so that we are seeing the trends of what are the legal issues going forward in the future, and we are trying to compare, each year what are the trends. So I think, hopefully, already those topics are already discussed in this panel, but hopefully I can provide some of the background data for what's going on globally. So it's very tiny words, so I think please take a look at it in the report if you want to see. But we are actually dealing with at least 16 themes at this moment. If you can see the people column, so we are discussing what's the issues or mental health issues for the lawyers, or the last one of the people is that how to attract the new talents into the legal community, or the clients, issues or business issues. We, of course, a lot of AI-related topics here, and also the rule of law topic. We are now seeing a lot of difficult issues about the rule of law or independence of the lawyers. So I think that those are also in the topics. And what we have been doing is actually we are collecting the responses from basically from all over the world to compile all the data regionally or globally. And we are yet to have this enough responses. Last year we have around 174. The year before we have around 255. Hopefully we will be opening our survey later this year, and hopefully we want to get at least 500 responses globally. And we only had 23 responses last year from Latin America. So here I'd like to also promote and encourage you to contribute to the survey if possible later this year, so that we can have more data to discuss. And I'd like to use some of the chart going forward. It's a bit tiny, letters, but you can take a look at it in the report. So firstly, we are checking what is the short-term impact for the legal community and what is the mid-term impacts for the legal community. And if you can take a look at it, of course, AI, as we are discussing here, AI is one of the most concerned topics. So AI is number one. And also AI-related issue is probably number 4, AI legal tech issues, and number 5, client expectation around AI. Those AI-related issues, of course, are very important in a short-term basis. But last year, we have a very clear trend that, the second one, if you can see the political uncertainty, or number 6, you can see the independence of legal profession. Those kind of issues are, of course, becoming more important going forward. On the other hand, for example, DI comes very end of the chart. DI is becoming sort of, I wouldn't call it less important. DI issue, ESGs are very, very important, but we are seeing more important issues on the short-term basis that we are seeing here. On the other hand, on the midterm base, so midterm base actually still, of course, AI is the hot topic. So all number 1, number 2, number 3, all these AI issues. And number 4 is actually we are discussing for the teaching, but how to attract young talents into the legal community. That's becoming the 4th one. And the political uncertainty or independence are becoming less important for the midterm basis. We can see in this chart, this is comparison between 2024 responses and 2025 responses. And if you can see in the blue one is actually, the increased ranking. Clearly, political uncertainty, number 2, and also a bit less than that, independence of legal profession, that increased quite a lot, in 2025 because of the current environment. And as you can see, as we discussed, the below the gray one on the left-hand side, green one is actually the ranking actually decreased. So the ESG, the third one from the bottom, ESG actually has very, very, decreased ranking, But again, I'm not saying that, this is not important. This is still important, but we are seeing more important, probably, or more urgent issues that we are facing on. So that's actually clearly showing the trend of the legal community globally. And this is also the comparison between 2023 to 2025. And again, as we are saying that, ESG has, the red one is actually ranking down. So the ESG or mental well-being or the D&I, those are unfortunately ranking down. But on the other hand, the jurisprudence, the independence of the jurisprudence, so those kind of issues are increasing. And this is even more complicated chart. So please take a look at it in the report if you want it. But it is comparing, what is the short-term impact? So the bottom line is short-term, impact, and the other line is readiness. So I think whether we are ready for any short-term impact, or we are not ready for the short-term impact, or we are not ready for the long-term impact, or the other way around. So I think we are kind of mapping all the legal issues of 16 themes, in this chart. So it's very interesting to take a look at it, and this gives you a clear data. So I think, any topics that you're interested in, you can take a look at in the 2025, report, full report, 2023 report. You can take, you can get some of the information. So please use it as an information source. And in my, conclusion slides, but actually this is my observation. So I think probably any of you have different, observations. But in my view, probably short-term impacts, as data shows, short-term impact, which means that political uncertainty or in sense of independence of the legal profession, these were high, but as we can see in the mid-term impact, they actually ranked down. So I think which means that probably they might have already peaked. So probably we may need to focus on more long-term basis, mid-term basis, issues. One of which is, I believe, the how to attract the young talent into the legal community. That is the biggest, one of the biggest challenges. And in the blue box, I think, well over 90% expect the talent attraction and retention to be a challenge in both the short and mid-term. So I think this clearly will be the challenges for the legal community going forward. And on the long-term basis, clearly, I guess we all discussed, but for the AI issues. But AI-related issues are many. So I think, AI issues are related to the how to train the lawyers and staff, or integrating AI to your legal practices, or a competition from the new entrants into the legal services, like tech company, legal tech company, provider, platform provider. We need to compete with those issues. And also, we need to adapt a new business model in the AI-driven environment that we have been already discussing quite a long time for today's panel. And 97% expect that the emergence of new unregulated entrants to be an impactful challenge in the midterm issues. So I think we tend to focus on the short-term issues, but we should focus on the midterm issues. They are probably long-standing, challenging issues for the legal community. And I have been telling all the kind of negative citizens in this thing, but I believe myself in I'm a bright future of legal services, because as we are discussing, human beings can work as a lawyer at the end of the day. So I'd like to conclude this wording for the future of legal services, as I learned. Viva Saúde and Kampai for the future of legal services. Thank you very much.
Bem, eu acho que depois
Well, I think that after Dr. Hideaki Umemitsu, we can be certain that the problems are common. And I think that the common data that connects all of us, not just Brazil and Japan, but the whole world, is AI. The use of AI, the dimension that AI has, the space it's going to occupy in our day-to-day. And now, to finish, we're going to listen to Dr. Kengo Kashiwa, that has been in the Japanese law since 2023, the member of the TMI Associates, one of the biggest lawyer offices in Japan, and currently worked with Cisco Bahia in Brazil and Bombo Sierra in Mexico, aside from acting with TMI itself. Professional practice was initially geared towards entrepreneurial right or law, but deals with several sectors nowadays. Throughout the year, it divides his activities between Mexico, Japan, and Brazil. Please. Good afternoon, everyone. I'm a Japanese lawyer. It's a great honor to be here today. I'm in Brazil, but working in Mexico. Unfortunately, my Portuguese became Portuguese. I'm going to give my presentation in English.
So again, good afternoon, everyone. My name is Kengo Kashiwa. I am a Japanese lawyer. First of all, I would like to thank the Embassy of Japan in Brazil and the Supreme Court of Justice for giving me this opportunity to speak today. It is a great honor to be here today. Today, I'd like to talk about the future of the legal profession. When the Embassy of Japan gave me this topic, I thought that they wanted to me talk about something related to AI and its impact on the legal profession. But many speakers today already spoken about AI. I would take a little bit different approach. I'd like to share my own experience as a lawyer. I think my career is quite unique. Before I start my presentation, let me briefly introduce myself. By the way, this photo was taken at the stadium of Copa America 2019 final, where Brazil became champion. I love soccer. Then, as I said, I'm a lawyer, but I've been living in Latin America for about 14 years. I lived in Brazil about 14 years, and I'm living in Mexico. But I do not spend all year in one country. I spent about 6 months in Mexico, 3 months in Japan, 3 months in Brazil, and 1 month in other countries like United States. So I went to Uruguay in March this year. So when I became a lawyer, which was in 2003, I never imagined that I would end up working this style. I never planned any of this. So this is what I want to talk about today. I think many of you have heard this prediction. AI will replace the legal profession in the future. For example, Goldman Sachs predicted in 2023 that 44% of legal work could be done by AI in the future. And the other experts also predicted the similar predictions. But of course, predictions have often been wrong. Let's look at a few examples. For example, computer science. For years, people believe that a degree of computer science guarantees you a good career. But this is no longer available. Recently, so this is a comment of the CEO of NVIDIA. So he also said that instead of computer science, electricians, plumbers, iron workers, so something physical jobs are in high demand. And this is another example. So in 2016, the Obama administration predicted that 2 to 3 million truck driving jobs will disappear in the future. But it didn't happen either. So in United States, there is a huge shortage of truck drivers at this moment. And the final example from my own career, as I said, I cover all of America living in the region. But 10 years ago, almost nobody believed that this kind of work style was possible. Of course, that technology already existed, like Skype. We could do remote work using those technologies at that time. But at that time, it was not possible because society did not allow it. What changed was not technology. What changed was society. Then I think here's a question. As I said, AI could replace our job in the future. But like many professors here said that, is it the legal professional still good career or good future? My answer is yes, because every day working as a legal professional, we naturally develops, automatically develops very important skills in any kind of career. I believe those 3 skills are useful, important, any kind of skills that we develop through our daily works. First one is fact-based judgment, and second one, logical thinking. And the third one is critical thinking. Of course, AI can help us in doing our job, but AI sometimes invents false fact, or AI sometimes seems very confident, even if it is wrong. So we can find this mistake, or we can think if the answer from AI is correct, or not only from answer from AI, answer judicial precedent or laws or comment from our colleagues. So we have to always do critical thinking or logical thinking and on the fact-based judgment. So these are very important skills that we develop every day. So AI may allow one legal profession to do much more, but I believe that does not mean AI will replace us. It may mean more freedom and more opportunity, like I'm doing right now. We can do what we can choose where we live, or we can choose how we work. So the future, of course, uncertain, and probably AI will replace us in one day. But we can adapt such a future and succeed using the skills that I mentioned. So this is my presentation, and before I finish my presentation, I want to show my last picture. I was at the stadium of the World Cup game between Brazil and Japan, and parabéns para todos Brazilians. Thank you very much. Muito obrigado.
Muito obrigado, Dr. Kengo.
Thank you very much, Professor Kengo. This brings us some hope. I think clearly human is still going to be essential. AI is present, but will not take a human's place. I'd like to thank everyone for being present here. I don't know, will I call the next panel already? Okay, so Professor Carlos Murta and Professor Watanabe for the closing speech.
A gente fica atrás das cadeiras. Frente das cadeiras. So now we are going to start the closing ceremony already now. And this closing session is going to be moderated by my dear friend, Justice Carlos Muta, from the Federal Court of Appeals for the Third Circuit. As a keynote speaker, we have Professor Kazuo Watanabe, that does not require any kind of introduction. We already have the two ambassadors and our special guests today that are going to speak right after Professor Kazuo, and the president of the Brazilian Association of Judges, the ANB, pardon me. Without further ado, I would like to pass the floor to the moderator, Justice Carlos Muta. Good afternoon, ladies and gentlemen. First of all, I would like to thank the organizers for the event, for the invitation to take part in this event. I would like to thank Chief Justice Herman Benjamin. Congratulations for this initiative, for the creation of this Brazil-Japan Law Congress. This is a single opportunity for us to strengthen our bonds, the bonds between the Brazilians who have descended from the Japanese and our fellow citizens who are in another continent, and they have been impacting our culture, and those necessarily that are not descendants. So Chief Justice gave me the job of introducing Professor Kazuo Watanabe. We don't need to introduce him. Let's pass the floor directly to Professor Kazuo Watanabe. I would just like to make a few comments and to mention what Professor Kazuo Watanabe represents to us. Professor Kazuo is a first-generation Japanese descendant. He was born in the 1930s. He faced the post-war period that was very, very difficult for all of the Japanese descendants. However, even though he faced all of these difficulties, he was a pioneer in the academia, in the legislature, in the judges' field arena, and he continues inspiring a whole generation. We don't remember Professor Kazuo as a prosecutor or a justice from the São Paulo court. We remember him as a great humanist, and he has always taught about the future generations. And I believe he's going to talk about that, about the challenges for the new generation of judges. And if we could summarize everything, I would like to say that Professor Kazuo is a professor of professors. He's a professor of legal experts, a professor of jurists, and a professor of several generations of today and of tomorrow. He's all of ours. He's a professor of all of us. So with you, Professor Kazuo. Thank you, Justice Carlos Muta. Thank you, Chief Justice Herman Benjamin, for the opportunity to be here, taking part in the second STJ Brazil-Japan Law Congress. I attended the first one, the first Congress, and now I'm taking part in the second Congress. And I acquired knowledge. I heard a lot of knowledge, vast knowledge. And the knowledge shared it's going to help me make certain remarks. And after taking part in this event, attending the presentations given in both congresses, I have a reflection about the role of the judiciary branch based upon all of these transformations of the public and private laws. First of all, based upon the outstanding presentations that I heard during these two law congresses, it has become very clear to me that both in Brazil as well as in Japan, there is a clear trend for the publicization of the private law and the privatization of public law. And this is happening in Brazil in a very strong manner, mainly after the 1988 Constitution that set forth with essential principles the dignity of human beings, social solidarity, the protection of those who are the most vulnerable, and also the insurance of other essential rights. These essential rights or fundamental rights, pardon me, they independ from a legislative interference, as the Constitution itself says in its first article. The first article of our 1988 Constitution. And I would like to share with you something to think about, something to ponder on from Mr. Comperato regarding this model that the 1988 Constitution adopted. It says the following. He says the following. The organization of modern states, as expressed in certain more recent constitutions, it's clearly theological. What do I mean by that? The public branches, more and more, we have fundamental rights that should guide their action. And he adds the following. The new constitutions, they do not limit themselves to define the mandate or the competences of the government agencies. They give a direction to their joint action as the constitutions from the liberal model. And they started from the presupposition that the state should ensure to each person their free definition of their targets of life without setting any general target or direction to our society. Resulting from this guidance, which is theological and part of the modern law, the essential role of the state is not the creation of laws, the balances of conducts that compensated the classical authors, but above everything, the creation of public policies or government action programs in all of the levels and sectors. And in playing this role, he emphasizes that the people should have a relevant role as well. The judiciary branch's work as a consequence, and this is my reflection for you, should be substantially transformed so that we can keep up with this evolution. And considering that the greatest violations to the legal order, they are practiced by the contemporary states by omission, because they don't follow the constitutional laws or they abstain from implementing the necessary public policies so that we can offer the socio-economic rights to our populations. So the understanding of constitutionality that was one of the greatest invention of the North Americans should be extended to the laws and administrative acts and to the public policies. They are not separate actions, isolated actions, but something that we characterize as an activity. So a set of actions of all varied kinds, laws, ordinances, contracts, etc., organized as action programs with a certain public purpose. These are the reflections that Mr. Comparato made, and they made me understand that when we are trying to reach or ensure the fundamental rights, all of the government agencies, even the judiciary branch within its mandate, and also our societies, they should work together So the judiciary branch's work should not limit itself to solving conflicts only when a lawsuit is filed. Okay, this is its specific mandate, but it should be more active in the organization of our society. We know that the Brazilian society still presents a high level of illiteracy. About 4.9% of our population who are 15 years old or older, about 8 to 9 million people, they are absolutely illiterate, absolutely illiterate. And besides that, besides this number, we have a high number of functional illiterate people, people who cannot interpret the letters, the numbers on a page, but they can codify them, but they cannot understand simple texts or do simple basic mathematical calculations. These functional illiterate people, they represent about 29% of the Brazilian population who are between 15 and 64 years old. And this deeply impacts the right to their access to justice, because people need to understand that they have the right to this and that this right is being harmed. And this perception is impacted by their illiteracy or by their lack of access to information. So the judiciary branch's role is not only to solve conflicts based upon the lawsuits filed. It must be more active, informing, guiding all of its members. And to a certain extent, this was faced head-on by Resolution 215 that tried to reduce the problem by creating SEJUSC with three main purposes. And one of its main purpose is regarding the citizenship sector that aims to guide the judges, the members of the judiciary, even before a lawsuit is filed. Its fifth article, paragraph 74 of the Brazilian Constitution, talks expressly about the right to guidance, legal guidance, integral legal guidance to those in need, to vulnerable people. It doesn't talk about support, assistance, or procedural assistance, but legal assistance. And so we should offer guidance to them even before the lawsuit is filed. And this is a serious problem because many people don't admit that the judiciary branch can guide or assist. But I believe that this is a fundamental right that comes from our Constitution. And the National Justice Council has already considered SEJUSC, given it SEJUSC this attribution. And many SEJUSCs are not implementing this. They are not implementing these services, not yet. Another attribution that the judiciary branch has, which is important, has to do with how to deal with the conflicts, okay, or disputes. So the judiciary branch can work by provocation only when a lawsuit is filed. And so this is the guidance. And so it's a neutral activity, passive activity on the part of the judiciary branch. And I have been saying that the judiciary, based upon the transformation that occurred from the 1988 Constitution, should be more active in the resolution of disputes, okay? So when we notice that there were repetitive demands, we have to activate certain sectors, and we should organize ourselves to do that and to research or do a research about what are the causes of these disputes. Nowadays, what we are doing, what we have been doing, is trying to face the effects of the repetitive demand via procedural instruments such as the resolution to solve repetitive lawsuits or repetitive problems. And what our Constitution says is that the judiciary should have and should play an active role. And when we have repetitive demands, we should face them before they become judicialized. I would like to mention an example that happened at the federal level here in Brazil. Those who work at the federal level, do you remember the demand? De-retirement of people. This happened with thousands, dozens of thousands of people, and the judiciary branch understood that the people retired in Brazil. So the retired people in Brazil, in order to complement their income, they started working once again. And regarding their income or the revenues that they had, they went to the pension that they were receiving after they retired. And so we had a regulation that allowed these retirees or retired people, once they retired, they could receive a bonus, a prefix value, another one. But the Social Security Institute revoked this regulation. And then we started having demands of de-retirement of these people. And there were thousands and thousands of these lawsuits. And then the Supreme Court said, the people who have retired don't have the right to anything. And so in the survey that we did, and people did based upon our recommendation, the director of the research department of the CNJ, the National Justice Council, said the judiciary branch should have adopted, should have been more proactive to determine what is the cause of this repetitive demand, this repetitive lawsuits. Okay. So these are the reflections that I wanted to share with you because the time is very limited, okay? And so I would only like to share these reflections with you. Thank you very much.
Bem, queremos aqui registrar os nossos cumprimentos.
So we'd like to greet once again Professor Kazuo Watanabe that with his speech instigated Brazilian magistrates even more to rethink their role in regards to new rights and the new social dynamics. Closing therefore now this panel, I hand back to the Chief Justice Herman Benjamin. I'd like to thank Justice Carlos Muta, and even more so, Professor Kazuo Watanabe. In the morning, I mentioned the way how my mentor Pellegrini would describe the text, my mentor would describe the text by Kazuo Watanabe: concise, clear, profound, and complete. But observe that this capacity of being concise is not just in his writing, but in oral communication as well. And in these few minutes, Professor Kazuo Watanabe has described the judiciary that is in the Constitution and that many still refuse to see, and even more to respect. The fact that our Constitution is full of rights and obligations, in the vision of Professor Kazuo Watanabe's, and I think mine as well, and also that of Justice Nancy Rodrigues and several colleagues, in our view, it is not enough because it comes from the constitutional text itself, the duty that we all have of teaching people that have these rights, that they exist. And if you want, the need is so obvious, but in Brazil it's not obvious, but the need of these rights being enforced and the obligations as well. On the other hand, in his intervention, he made it clear that a legal power that that watches this neutral and passively to the multiplication of litigation with hundreds of thousands, to the hundreds of thousands, especially of the most vulnerable, without there being an answer, it is then the judiciary itself that is not respecting these rights and obligations, and not only those that are considered the accused in these litigations. We have a lot of gratitude for these decisions. He is now at the STJ, the most cited Japanese descendant jurist. He has been retired for many years, but it is hundreds of reports of mine where we cite Professor Kazuo Watanabe's lessons.
Professor Kazuo, volte sempre. Nós contamos com sua presença.
Professor Kazuo, please, you're always welcome. We love having your presence here, not just in Brazil-Japan, but at events on Brazil as well. We always need your counsel.
Passamos então à sessão de encerramento. E eu queria agradecer a presença para nós.
And I would like to thank the honorable presence here of the ambassador Yasushi Noguchi that has been with us yesterday and today, and was with us yesterday evening as well. Those who were unable to go to the reception, I'm sorry. You lost an excellent moment where they could have been at the Japanese residence of Ambassador Yasushi Noguchi. I'd like to thank the President of Ambassador Susan Klebank. That is a reference for Brazilian diplomacy. She has under her umbrella a region that is geographically huge, Asia and Pacific, but Asia that touches all the way to Europe and the Middle East. It's an empire, so to speak, in terms of diplomacy. And she's really fantastic in her work and the collaboration that she contributes to the STJ. So special thanks to Ambassador Susan Klebank. Thank Aline Akievi that represents the Brazilian Magistrates Association. In the opening we had the Association of Federal Judges and now the Association of Magistrates, AMB. I'd like to request that Justice Nancy take her seat here at the table, because I have to go to the official photo of the other event that is taking place at this moment, and they're waiting for me. And if you could please preside this closing ceremony, leaving my thanks to all that are here. We'll then later have our official photograph and the signature of the important document. It gives origin to the Brazil-Japan Consortium of Schools of Law. So, Justice Andrighi, please.
Good
morning to those that I did not previously greet. I had the opportunity of hearing the final words of our dear Professor Kazuo Watanabe. Forgive me for not having been here, but I'm almost like the Chief Justice. I was in another event of arbitrage that was taking place at the same time. So my apologies, Professor. I wish I could have heard you from the start. I wish I could have heard this final message that you gave to the magistrates here. It's extremely important. And I was thinking, meditating, I'm going to complete almost 50 years as a magistrate in the next day of 18th of December. And I was thinking to myself how much I failed. Because I never stopped to think that I could have taken the initiative in many situations and avoided litigation. Your Excellency, Professor, you really touched me. Because, especially at the end of a career, we end up doing a stock take of what we did. And it left me really concerned. I will try, Professor, this last year that is left to me as a magistrate. I will reach the age limit next year. I will try and take forth this message that you gave us. Thank you, Professor. So I want to thank you all. I want to wish those who came here from so far away. I would like to wish you a great return. I hope you have everyone finding their homes in peace when you're back. Thank you very much for your company. And I hope you know all that the results of this energy that you've left here with us will be used and fruitful for a long time in the future. Thank you to all that gave us speeches. Thank you for sharing with us part of your knowledge. And to thank Justice Carlos Muta. Thank you for presiding, or for chairing this panel. I'd say there was a true present for all of us to have our Japanese colleagues present here. And I'd like to repeat, you are invited to many other visits. Thank you very much, and with the authorization of Justice Muta, I declare the session closed. And this beautiful event that brought us so much joy and knowledge. Thank you very much. I'm being told that I should have handed over to the ambassador. I apologize. Justice Herman did not let me know. So I hand over to Ambassador Susan. My apologies. I hand over to you for 5 minutes. Thank you very much, Justice. So, dear Justice, Ambassador Yoguchi, Justice Jacqueline Alieve, Professor Watanabe, magistrates and professors here. It is an honor to represent the Itamaraty at the closure of this Congress. It's also a great pleasure to come back to this house. In the first edition of this Congress in August last year, in the Seminary of Cooperation Brazil-Asia-Pacific in April, the dialogue between Itamaraty and this court has become an exemplary example. The example of the Chief Justice of STJ. The Congress approached the publicization of private law and the privatization of public law, trade, supply chains, defense of consumer, and the future of legal profession. The subjects give a clear idea. It's in private law that the great economic, social, and technological transformations of our time reach the contracts, the companies, the consumer relations, family, and the protection of people. It is also in this plan that trust between society is built case by case. For the Brazilian external policy, legal cooperation with Japan has a strategic reach and the supported introduction of over 130 years of relationships between the two countries. This base has gained new boost with plans for strategic agreement 2025 to 2020 to 2030, and with the launch of agreements of economic partnership agreement announced on the 30th of June. It's with this in mind that Itamaraty participated yesterday in this debate through the Secretary of Economic and Financial Affairs. There is no sustainable trade without trustworthy contracts, nor long-term investments without foreseeable decisions on both sides. The negotiations that start now need compared knowledge that this Congress is cultivating. Our legal traditions are different, but we share roots in the Roman Germanic. This common base facilitates comparison, and the differences make the legal dialogue even more fruitful. So it allows the communities to connect both countries, the descendants of Japanese in Japan and Brazilians in Japan and Japanese in Brazil. All the question of family, succession, consumption, and all legal questions for these people is not an abstract question. It's a daily need. Professor Watanabe and Yomiya are for decades the consultants and the builders of these bridges. Lastly, there's a convergence that goes beyond private law. Brazil and Japan are democracies that trust in their legal institutions and defend an international order founded on international law. In times of tension, of the rules that organize the living between states, the battle between magistrates, reaffirms that legal assertion continues being preferable to that of force. I congratulate the STJ and the International STJ program for this initiative. And I thank the Embassy of Brazil, the University of Hitotsubashi, and the magistrate associations, and all those that contributed to these 2 days. The most lasting results will come after today, in cooperation between the institutions, academic exchanges, dialogue between magistrates, and we hope in a third Congress that Itamaraty will continue committed to this strategic and partnership between Brazil and Japan. Thank you very much. Thank you, Ambassador Susan, who is always with us at the events here. It's a great pleasure to have you here in our house. Thank you very much. And I'll hand over to our dear Ambassador Noguchi for his final remarks. Good afternoon. Thank you very much, Justice Nancy. I'd like to greet Ambassador Susan Cleveland. Thank you for your presence. Thank you, Your Excellencies, for being here and for your presentations. I'd also like to greet Ambassador, and now I'm going to speak in English.
During this law conference, 5 panels discussions were held over 2 days, and fruitful discussions took place among Japanese and Brazilian participants. This law congress marks the first time that as many as 15 researchers and lawyers from Japan have visited Brasília. I would like to once again express my deep gratitude to Chief Justice Herman Benjamin for his efforts in hosting us, as well as to all Japanese and Brazilian participants who took part in this conference. I have also been informed that there are plans to establish a permanent framework so-called consortium to enhance academic cooperation between Japan and Brazil. The Japanese embassy is delighted to see such proactive efforts and will provide all necessary assistance. There are high expectations for strengthening relations between Japan and Brazil now. I strongly hope that this Law Congress will lead to even closer ties among scholars and legal professionals from both countries, and that these exchanges will continue more than before. And particularly, I would like to be very grateful for University of Hitotsubashi and Fundación Getúlio Vargas to lead this consortium, and I strongly hope that this consortium will really strengthen the academic cooperation, particularly judicial cooperation between Japan and Brazil. Thank you very much. Muito obrigado.
Thank you very much, Mr. Ambassador, for your cooperation, for the work, for the encouragement, for your participation during this event that became better and better because of your presence. So I would like to pass the floor to Justice Jaqueline Alievi. She's our representative from the Brazilian Association of Judges. Good afternoon to all of you. It's an honor to be here representing the Brazilian Association of Judges, AMB, and our colleague has just arrived. And thank you so much for the invitation. I would like to thank the STJ. Thank you, Chief Justice Herman Benjamin, and also Justice also Adrigui, Nancy, and I would like to greet Ambassador Susan Kleeback, Ambassador Yasushi Noguchi, and Justice Carlos Muta, Professor Kazuo Watanabe for his keynote presentation, and I would like to break the protocol here. And we also have a justice here from the state court from the state of Paraná. I apologize for my voice. I have a sore throat, and I'm going to be very brief. As Mr. Cortes spoke in the first Law Congress, the friendship between Japan and Brazil defies geography and the laws of physics. We are exactly on opposite sides of the globe, but our friendship is strong, and we aim to even strengthen even more these relationships. We have human connections, as summed up by Chief Justice Herman Benjamin in the first Congress. Brazil and Japan, they are spokes countries, and they are based upon democracy. The organization of the Second Law Congress is an institutional achievement, and this was a first initiative, and we're going to continue with the relationships between our nations, and we're going to set a permanent bond between the judiciary branches in Brazil and in Japan. Once we decide discussing the publicization of the private law, consumer law, trade, and the supply chains, we continue facing a common question. How can the law respond to relations that are more and more complex, transnational, and interdependent, without renouncing the legal certainty? The old borders between the private and the public, they have become more and more porous. And so a supply contract mobilizes chains all over the planet. And millions of people can be impacted. A decision about data and algorithm can generate collective consequences. Private law, modern private law, is not only regulating individual rights, it organizes the economy, and it protects our social idea of the judiciary branch. That's why the second law, and it was able to talk about private law in a a precise manner, and we need to think about technology and the economy without forgetting human beings. As mentioned earlier today, we are talking about AI. We can never forget human beings. Modernization does not mean stopping the protection. We have to walk side by side, and we have to preserve our fundamental rights. That's when the judges play a vital role. We need to have predictability, reliability. They are not abstractions. They are part of the invisible infrastructure upon which we have trade, investment, and development itself. No economy can prosper if the contracts are not complied with and followed. So judges here, they are responsible for building one of the most important public assets, reliability and trust. That's why the continuous education and exchanging experiences, such as the experiences shared during this Congress, they help us to become better judges. Brazil and Japan, they have distinct and different legal traditions, but they face similar challenges as mentioned by the speakers. They learn with one another without forgetting to be who they are. Based upon this respectful dialogue and permanent dialogue is that we are creating better qualified answers to problems that don't belong to a single jurisdiction. The Brazilian Association of Judges restates its commitment with dialogue between different jurisdictions and making Brazil and Japan get closer expands our capacity to protect and offer jurisdictional answers that are better qualified. The geographic distance that separates us, may it continue being, as in the last 130 years, something that help us build new bridges. Thank you very much. Thank you, Justice. And the largest court in São Paulo, Madam Mateus, she is the president of the Brazilian Association of Judges. Thank you so much for being here. And I believe that now so with this, we conclude the event. I would like to ask permission from Justice Muta to say that this panel and this event is now wrapped up. And I wish to all of you safe travels back home and a wonderful afternoon and lunch. Thank you.